Unauthorized construction, whatever is illegal will go in due course of time. There's no problem with that. Give your slip. Madam, yes, tell me.
My lord, may I will also kindly to mention 8 identical matters, my lord. The petitioners are the Group D casuals, Group D staffs are Raiganj municipality, my lord. At the initial post, my lord, till date they are casual staffs, my lord. Group D's post, my lord, and my lord, they have sought for the regularization of their post, my lord, to the concerned authority, my lord, and their concerned authority rejected their
Give your slip. Give your slip.
my lord, for upgradation.
My lord, may
Give your slip. Give your slip.
upgrade.
We'll see. Give your slip, sir.
Daran, daran, nin.
Give it, madam. Give your slip.
Lordship, may I permit? My lord, may I be
Contempt application, my lord. Just a minute. Give your slip first. Contempt application.
May I permit to mention one matter?
Give your slip.
My lord, may I be permitted to? My lord, for inclusion, my lord. My lord, may I be permitted to mention?
My lord, may I permit to mention for inclusion? Inclusion.
May I permit to mention one matter for inclusion?
Give your slip.
My lord,
Upgradation.
I be permitted to let it be fixed and
For what?
Upgradation.
Give your slip, we'll see that, sir.
2018 and 2020.
Sir, give your slip, we'll see it. Give your slip.
My lord, although it's
Your
up
lordship,
for
petition
upgradation on the
is
last
senior
occasion, your
citizen.
lordship was
Kindly
pleased
fix
to
this
allow my
matter.
prayer for
Sir
upgradation.
Kundu, give your slip.
Your lordship,
Withdraw, my lord.
petitioner has a very medical issue. It's a heart issue. So kindly fix this matter. Your lordship.
Madam, we'll see that.
Yeah,
My
okay.
lord, with
My lord.
my lord's leave, my lord,
My
may I
lord,
be
may I
permitted to
leave to
mention, my
withdraw,
lord,
my
with
lord.
respect to Jalpaiguri Circuit Bench, my lord, since the circuit is not available till 11th,
Yes.
my lord, my demolition is fixed on, my lord, 5th of August. My lord, there is a second round of litigation where, my lord, again, similarly, my lord, on the first round when the demolition order was
Sir, file it, file it. Demolition, I am not very concerned about.
my lord, the leave to file because it's a pertaining to Jalpaiguri. My lord, since the circuit is not available, if I have to file in Calcutta, my lord, I need from my lord's officers leave. My lord, 11. My lord, 5th is the fix for demolition. My lord, the order, my lord, I have.
You have a sanction plan?
Yes, my lord, everything is there, my lord. They say there are certain deviations, my lord. This was directed to consider, my lord, by virtue of a notification that those minor deviations can be included or not. Now, my lord, they have not adhered to that too, my lord. And my lord, by application for regularization on basis of that notification is pending. And my lord, despite that, they have passed an order, my lord, on 5th of August for deviation of those minor parts. Otherwise, my lord, the building is standing on its own with sanction plan.
You are running a illegal pathological clinic.
No, my lord, not.
Let it be mentioned before the regular bench. No.
My lord, kindly appreciate, my lord, I have a. No,
Regular bench.
my lord,
Regular Jalpaiguri. No.
my lord, kindly appreciate.
No, sir, no.
My lord, then, my lord,
No, sir, no.
then, my lord, may I place it on merit, my lord? My lord says illegal pathological clinic, my lord,
Sir,
I have all the licenses.
Mentioned before the regular. Yes.
Contempt application, your lordship order. My lord, may I leave to withdraw, my lords?
Give your slip.
My lord,
See-
permitted to mention, my lord, I am mentioning for upgradation, my lord, respondent number 8, 9, 10, I call it. My lord, number 8, 9, 10 have illegally muted their name, property in their name and entered into a development agreement with respondent.
Give your slip.
My lord, I have given.
All right.
Lordship, inclusion, your lordship. The matter was
Yes.
running in the.
My lord,
list.
may I
Please
permit-
wait
Give
up.
your slip. Give your slip.
Well, item number 2744. It is a motion matter.
Very
First August 2002 matter will appear on 113. Now the matter is appearing 2744 hearing matter. It is a motion matter. Matter was not heard, my lord. Matter was kindly see. First day August, matter is appearing 113. Item number 113.
Why?
শুক্রবার এই শুক্রবার new motion is hearing matter is appearing hearing, my lord. No, hearing stage এসছে. Kindly see 274. Yeah, hearing it. 2744. 2744. 444.
My lord,
Just a minute.
the matter for the third time.
You can mention it as many times as you mention.
My lord, that the problem is that the KMC has sanctioned the plan on my land in favor of another person.
We'll see that, sir. Give your slip. We'll see that. Whether the land is yours, not yours.
Citizen, my lord.
Sir, These are disputed question of fact, whether the AMC has sanctioned it on your land, not.
It will hardly take 5 minutes of time.
Milord,
Milord, otherwise,
You all know what lands are there.
Milord, no, Milord, it is my land, it is parental land.
And
Very good.
Milord, kindly allow this, otherwise.
Give
this
your
is over,
slip,
Milord,
sir.
actually.
Let it go on. Go to the civil court.
Milord,
Sort out your land dispute and then do something.
This food.
Give your slip.
This is the slip, Milord.
Milord,
मैं मेंशन लिख के आया हूँ स्लिप देना
Slip दीजिए.
Milord, the 2 pages I have folded, Milord, since Milord has said that it's illegally running. Milord, by virtue of the previous order of this honorable court, Milord, the earlier order was quashed on the ground. They say that it's change of user. Milord, we have made an application under the Act Corporation which permits change of user. Milord, keeping that application pending, they pass a similar order again.
Mention before the regular bench.
Milord, regular bench is 11.
11th.
Milord,
That's all.
but till within this time, Milord, I
Nothing
will
to be
be
done.
remediless, Milord.
Nothing to
Kindly
be done.
appreciate,
Sorry,
Milord.
sir, I've seen it. Nothing to be done.
Milord,
Yes.
Pages, Milord, kindly sees,
Sir,
Milord.
I just saw it.
Milord, Milord has seen
I
the
just had a look at it, and that's why I am
Milord,
telling you
it's a
regular
different
bench.
order, but my application on the earlier order kindly be seen.
Sir, regular bench. Yes,
Kindly appreciate, Milord.
regular bench.
May it please your lordship, my lord, my learned advocate on record has already handed over the slip, my lord. The urgency is, my lord, it was heard, my lord, before the Honorable Justice Chondo was having the urgent determination. The matter was heard on 2 occasions. His lordship was, my lord, about to pass an order, but on the last day, my lord, on Friday, my lord, till when his lordship had the urgent determination, the private respondent, my lord, sought for accommodation on the ground of, my lord, unavailability of, my lord, their learned advocate. There was some death in his family. So, my lord, the matter could not be heard out. There is a threat of demolition, my lord. Citing that the building is in a ruinous condition, we have introduced by way of supplementary affidavit also. It's a 1-story building, my lord. It's in absolutely, my lord, in a
Give
proper
your
state,
slip, Mr.
my lord.
Milord,
But there is a threat of demolition, my lord. That is the difficulty. my lord.
Milord, may I have your
Great.
lordship's
my
kindly.
lord take 2744 it is wrongly my lord
क्या हुआ?
my lord kindly fix any date
Just a minute.
appear mention
It will come in the motion.
when my
There's a mistake which has been done by the, I think the filing section.
Milord,
yes yes Act 113 Act
You also give your,
matter was
we'll
not
get that
moved.
corrected.
The item now
I have given Milord.
All right.
Milord,
Motion stage, Milord.
We'll see that.
Milord, may I have your lordship's kindly, Milord, I am seeking for my lord leave to file this writ petition, Milord. The demolition on 6th of August, Milord.
Very good.
Milord, I have a BT appeal pending, Milord. They have not considered that, Milord.
You have a appeal pending before tribunal.
Yes, Milord.
Nothing doing.
Milord, Milord, kindly,
Nothing doing.
Milord, kindly appreciate.
Nothing doing.
Mention in this matter,
Yes.
that petition before lodging with the doctor, and I was a tenant at a particular premises from where I was running on my doctor's chamber. Now, my lord, the developer and the landlord entered into an agreement, and they also entered into an agreement with me, where they said that they will make multi-story building and my tenanted portion will remain there at the ground floor where I was. Now, my lord, my particular case is that they did not come to me for my signature at the no consent, no objection certificate. What they did is they forced my signature. I complained to police complaint. Yeah, my lord, it's the finding of the CID that the signature is forged. On this basis, I made an application before the Municipal Commission under 397 for revocation of the sanction plan, because this was done on fraud and misrepresentation. Now, my lord, the difficulty is that although that application is pending, the commission is not hearing that. Now, my lord, I have not been given that my tenanted premises from where I can run on my doctor's chamber, but I am running now outside the premises. I'm some difficulties, my lord. That is why I was beseeching your lordship, would be your lordship's pleasure to take up this matter any day. And only thing I would be
Give your slip, we'll see that.
my lord may I permit to mention
Give your slip.
my lord, may I permit to mention my lord in a dilapidated condition of building I am the co-owner I want to demolish that I have made representation municipality considered passed an order still the other sharers are not allowing to demolish it and one person got injured because of falling of half of the property my lord.
Give your
Including
slip.
a daily list my lord.
This is a daily thing here.
With your
My lord,
lordship,
this
leave,
is
may I
happening in
mention
a
a
rainy season.
recalling application. Recalling application.
Recalling of what?
Recalling of your lordship's order, Milord, because Milord, the address, Milord, of the respondents was suppressed, Milord, and the petition, Milord, was served on at the wrong address, Milord.
Give your slip.
My lord, my lord, the
May I
next,
take your lordship's kind leave
my
to
lord, the
mention?
next date before the tribunal is on 12th of November, my lord.
Sir, if you have approached the tribunal, I'm not
My lord,
listening to you.
Before,
right?
before they issued this notice, my lord, I have approached. My lord,
That's
in
all right. You
2020
don't have a stay from the tribunal.
No, my lord, because
Nothing
the
doing.
tribunal was not taking up matters, my lord,
Nothing
regular.
doing.
My lord, permitted to mention in restoration application, your lordship, for inclusion in the. My lord, a coordinate bench of this honorable court passed an order of demolition, my lord.
Yes.
My lord, if some other persons preferred appeal, my lord. Appeal court also passed an order that to hear other persons, my lord, pass it in. Order was passed, my lord, for demolition itself, my lord.
Very
It
good.
was not being carried out, my lord. I have filed an application, it is pending, my lord.
Very
I
good.
have filed an application also, my lord, in connection with that writ petition, my lord.
Very good.
That has to be heard, my lord. My application to be listed, my lord.
Sir, give your slip.
My lord.
What has to be heard, we will decide. Give your slip.
And my lord, division bench, my lord.
Give your slip.
স্লিপটা দিতে বলছি হ্যাঁ দিয়ে দিচ্ছি
Yes. Call out the list.
My lord, I am for the petition, my lord.
Well, item number 1, my lord, I am appearing for the petition virtually. My junior is there.
I have responded municipality.
Yes.
There are some pages in the vernacular, my lord. My junior is handing over the pages.
Translate.
Yes.
Not kindly comes to page number 16 once. Petitioners are employee of Banchperia municipality. Not kindly comes to page number 16.
Page number?
16, my lord. 16.
Yes.
But on 8th February 2019, Finance Audit Department of Government of West Bengal issued a circular fixing minimum salaries of the person. As per the circular, the temporary, casual, delegated and contractual worker who are serving for less than 5 years will get a salary of 12,000 and highest will be 22,000. For Group C, the lowest will be 13,000 and highest will be 24,500. And at the age of retirement, my lord, as per this circular, they are entitled to get a sum of rupees 3 lakh. Now, my lord, the petitioner are employee of the Banchperia municipality. Banchperia municipality has taken a decision of giving one-time retirement benefit to the petitioner at the time of retirement of rupees 25,000 and 30,000 only, firstly. And my second point is that the Banchperia municipality is not following the circular issued by the Finance Audit Department of Government of West Bengal, which applies to all authorities. Regarding that, my lord, on page number 24, 23, I have made a representation before the authorities.
You are working as? When did you join?
But I have retired now.
He is not mentioned when he is.
But admittedly, I am a contractual employee. I hope the municipality is not denying that position that I was a contractual employee of the municipality, my lord. Government circular is there. As employee of the municipality, I am entitled to get. But as page 23, I have made a detailed representation.
You are retired?
But I have retired, my lord, in 2022 and 23. But kindly comes to page number 23 once. At page 23, my lord, I have made a detailed representation before the authorities. That has not been considered till date.
Page number?
23, my lord.
Material from 25.
Yes.
On page number 23, my lord, I have made a representation before the authorities, my lord. And actually, it starts from page 25, other 22. In the representation, my lord, I have stated detail about the circular. I have said that the petitioners are not getting the benefit of the circular, and I have requested the authority to consider the representation and take necessary action. Till date, they have not considered. My lord, writ petition at this stage can be disposed of by directing the municipality to consider my representation and pass necessary orders. In terms of the memo,
প্রিন্সিপাল সেক্রেটারি করুন, তাকে তো দেয়নি। ডিএলবি করতে কি করুন, ডিএলবি করে ডিএলবি করুন।
Yes.
My lord, representation may be considered, my lord, I have no objection. But the circular is applicable only when there is a prior permission from the government to give any appointment. It may be casual or it may be permanent. But there is no mentioning either in the writ petition, not a single averment, that they have been appointed legally valid and how many days they have worked, when the appointment letter was issued, nothing has been mentioned. Only about the circular, that is the circular of the finance department. But let the, my lord, he has made the representation addressed to the secretary, Department of Urban Development. Let the secretary consider it, my lord, in accordance with law.
You are appearing for the secretary.
Yes, my lord.
This is for state. So for
I am for the state,
I am
my lord.
representing municipality. Well,
My lord,
municipality has nothing to say, my lord, because this is
because he is the employer, he has also to be represented. He is to be also heard.
yes, ma'am.
He will also be heard.
yes, yes.
Let the secretary decide. You have not given any details of your appointment, your retirement, nothing. No,
Nothing.
no document has been filed.
My lord, I am praying unconditional apology, but this
Apology
admitted
will
fact,
not help, sir.
but admitted
Mr.
fact,
Tiwari.
admitted fact that they are employee of the municipality.
Where
Municipality
is
not
the admitted
disputing.
fact? Where is the appointment letter?
But appointment letter has not been annexed, my lord.
Then how is
But
it
in that
admitted?
in that case, I can file one supplementary affidavit, my lord, if your lordship
Nothing
direct.
has been filed. What is there on record that you are working for the corporation?
My lord, municipality never disputed my appointment, my lord. Municipality never.
Where is the municipality never disputed, sir? Have they filed their counter?
No.
No, my lord.
Then
But
how
I
are you
was-
saying they never disputed your
My,
appointment?
I was working, my lord. My lord, kindly comes to my lord one page, my lord.
Sir, where is your appointment letter?
My appointment letter has not been annexed, my lord.
Then
My lord, kindly comes to page number 18.1.
you file a writ petition. I'll give you liberty.
My
The rest
latest,
of all material particulars.
my latest supplementary be filed, my lord. This is a poor
No
man, my lord.
supplementary. Either I'll dismiss it. What kind of writ petitions are filed? Or you withdraw with liberty to file a better writ petition with better particulars.
My lord, liberty may be given, my lord.
The petitioner wishes to withdraw the present writ petition with liberty to file a writ petition with better particulars. Full stop. Dismissed as withdrawn. Liberty is granted, dismissed as withdrawn. And nothing is there. Take it. Other part.
For the petitioner in this matter, my lord.
Yes.
Item number 2. My lord, in front of my house, we have, in the year 1980, there is a petrol pump in front of my house. Thereafter, my lord, that problem was solved, but we are staying there. A petition suit was there also, but surprisingly enough, my lord, respondent number 4 issued a trade license in favor of respondent number 8. trade and investment certificate. And he running a car parking center in my front of house and, my lord, in front of that petrol pump without any authority. He is neither a tenant nor a licensee nor anything. We are the owner. My ingress and egress has been stopped.
My lord,
My
I am behalf of HMC. I am junior of Sandeepan Banerjee. Sir is occupied in another work. So please reschedule this
We'll have it
matter.
tomorrow, not today. Tomorrow. Tell him to take instruction. Tomorrow, not today.
Thank you, my lord.
কাদের হয়ে বাবা? আপনারা কাদের হয়ে? মিউনিসিপ্যালিটি? কাদের হয়ে?
Agency.
আচ্ছা, হ্যাঁ, ঠিক আছে, ঠিক আছে, ঠিক আছে।
আপনি তো রেসপন্ডেন্ট, ওদিকে চলে যান।
আমার নাম
Lord, item number 4, 3 and 4, my lord, was hearing together. 4, my lord, is the matter where I have challenged the order of demolition. 3 is the writ petition filed by my learned friend seeking implementation of the order of demolition. Our brief. Lord, the Asansol Corporation ultimately filed an affidavit in terms of Lordship's order, my lord. We have used a reply. Lord, before, Lord, here the principal ground that I have raised along with other, my lord,
There is a reply.
inter alia is that, my lord, that the person who has passed the order, he doesn't have jurisdiction to pass the order. My lord, very recently, I was moving another matter before Justice Chondo. Justice Chondo has passed this order, my lord, against which an appeal has been preferred and the appeal is pending before the division bench. On the similar ground, my lord, the writ petition was filed. My lord, I had the occasion to address the court, my lord. If my lord sees the order, Mr. So-and-so, learned advocate appearing for the petitioner challenging the impugned demolition order appearing at page so-and-so on the ground that superintending engineer of Asansol Corporation lacks jurisdiction to issue such an order under West Bengal Municipal Corporation Act, same like the present case. Placing reliance on 266, Mr. Chakraborty submits that the power to issue a demolition order is vested solely in the commissioner and cannot be delegated to any other officer of the corporation. Therefore, it is contended that the commissioner must personally exercise such power. In response, Mr. Saunak Bhattacharya, learned advocate appearing on behalf of the Asansol Corporation, has produced a notification dated February 9 and argues that the superintending engineer is empowered to issue demolition order pursuant to the authority conferred by the notification under 47(3)(b) of the West Bengal Corporation Act. Having regard to the order I propose to pass in the present, I do not find it necessary to adjudicate upon the issue. But the writ petition was allowed. The court was of the view that it has merit, but ultimately it was allowed on a different ground. Lord, what I was beseeching your lordship subject to your lordship's kind sanction, since an appeal is pending against this order.
Nothing doing.
Very well. Lord, I'll proceed with the matter.
Your lordship, before
So-
my learned senior friend proceeds, Mr. Shonak Bhattacharya, I am led by Mr. Shonak Bhattacharya, his matter is representing the Asansol Municipal Corporation engaged in courtroom number 10, your lordship. Your lordship kindly takes it up tomorrow in that case because the interim order is till 15th.
Till 15th of August, the interim order is there. Lord, the issue that I am raising, if I may show the statute to your lordship, Lord, kindly take up the 2006.
As far as your argument is concerned
Hello?
about the superintendent engineer not having the
Mal-
power, that
Mal-
issue has not been dealt by this
That-
lordship.
yes, that Lord, the court, I should be very candid, Lord, I showed that paragraph, that is why.
Yes.
The court was of the view, the corporation could not answer it during the hearing. But the court, Lord, said that if I decide, I should not say this, if I decide the issue, several matters will get affected. Lord, the courts allowed the writ petition on a different ground. That issue, Lord, your lordship will, I beseech your lordship to decide. Lord, may I place the Lord legislation? The statute is absolutely clear. What is to be done, under what circumstances is to be done, and the corporation has come up with a one-pager which says that the commissioner has allocated. Lord, there are two provisions. One is a general power of delegation, and the other one is section 266. 266 has three provisos. The third proviso says that the commissioner can only delegate the power of first and second proviso. 266(1) deals with the power of the commissioner to pass an order of demolition. 266(1) first proviso says that there has to be a show cause notice issued.
Second proviso says there has to be a stop work notice issued. Third proviso says that the commissioner can delegate the power of first and second to a special officer appointed by the state, not even to an executive engineer. I am trying to make a submission that 47(3) applies to a general power of delegation. Commissioner has several duties in the corporation. But when there is a special provision for a particular act to be done, and it says that you can only delegate up to a level, not the final order. It has to be by you.
And where do you get that up to a certain level?
It's there in the statute, proviso 3. And I will rely on 2 judgments of the. I'm just giving a broad line of my judgment.
According to you, every order of demolition should be passed by the commissioner and
But
only commissioner.
My humble submission, why I say so, because in the Corporation
What
Act,
authority you have to support that contention?
yes, from 2 judgments of the Supreme Court, which says if in a statute there are 2 conflicting powers.
Sir, when was this statute came into power?
Lord, this is of 2006. I am carrying 2 judgments, one of 1961, one of 2019. 2019 judgment, which is
of this High Court?
No, of the Supreme Court, which says
that this issue must have been dealt by.
Lord, I tell you also what happened in the Kolkata Corporation in Sushoma Saha's matter. What happened in the Kolkata Corporation?
Not only Kolkata Corporation, everywhere the demolition orders is generally passed by the superintendent engineer or the executive engineer.
I tell you also why. Lord, in the Kolkata Corporation, the special officer building, there's a matter came up before Justice Tandon. I'm carrying that judgment, 2015 5 CHN 309. For your Lordship's kind consideration. There what happened, the Kolkata Corporation Act says you have to delegate, you can delegate, the power of delegation is there to a particular officer. Now they were delegating to retired officers. The matter came, Justice Tandon laid down the law. Here, there are 2 conflicting provisions. One is a general power, one is a special power. Now Supreme Court says if there are 2 powers in the same statute, the special power which deals with that particular provision will apply. It's like a general condition and a special condition. But I am carrying that. My Lord, can you take up the statute first? If my Lord takes up 2006 West Bengal Municipal Corporation Act. But should I give you also my book? Lord, 2006.
Yes.
The green one, perhaps.
Edition.
Now, that is perhaps the red one is the old one. There has been an amendment of the statute.
Yes.
Now, kindly come to 266. But may I place it for your Lordship's kind consideration? Yes. Where the erection of any building or the execution of any work has been commenced or is being carried on or has been completed without or contrary to the sanction referred to in section 263 or in contravention of any of the provisions of this act or the rules and the regulations made thereunder, the commissioner may, mark this, the commissioner may, in addition to any other action that may be taken under this act, make an order directing that such erection or work shall be demolished by the person at whose instance the erection or the work has been commenced or is being carried on or has been completed within such period, not being less than 5 days and more than 15 days from the date on which a copy of the order of demolition with a brief statement of reasons thereof has been delivered to such person as may be specified in the order. So it is the commissioner to do it. Then first proviso, provided that no order of demolition shall be made unless such person has been given by means of a notice served in such manner as the commissioner may think fit, a reasonable opportunity of showing cause why such order shall not be made. First proviso. Then second, provided further that where the erection or the execution has not been completed, the commissioner may by the same order or by a separate order, whether made at the time of the issue of the notice under the first proviso or at any other time, direct such person to stop the erection or the execution until the expiry of the period within which an appeal under against the order of demolition, if made, may be preferred under subsection 3. But I'll not invite your lordship to the explanation. Kindly turn the page, come to the third proviso. Provided also that the commissioner by order delegate his power, but his power and functions under the first and second proviso of this subsection to the special officers appointed by the commissioner with the approval of the state government on such terms and conditions as may be determined by the corporation, and the expenses for payment of such officers shall be borne by the municipal fund. But if you lordship kindly consider proviso 3, the third proviso says that his power and functions under this section 266 is the particular section which deals with the power of demolition. Corporation has filed the affidavit admitting that the order of demolition has been passed under 266. So to whom he can relegate? He can relegate proviso 1, proviso 2 to a special officer appointed by the commissioner with the approval of the state government. So third the power of issuance of show cause and the power of issuance of a stop work notice has been given that the commissioner may delegate. Now, my lord, why this? In my humble understanding, my lord, the legislature was quite conscious that an order of demolition is the highest amount of penal action that could be taken under the statute. That is why, while allowing him to delegate, it has restricted him that you delegate only first proviso and second proviso. You cannot delegate the main power. Lord, my lord knows proviso not qualifies the section. The power of the commissioner to pass an order of demolition is there in 266(1) itself. 266(1) third proviso says you can only delegate up to a certain portion. So the rest of the portion you have to do it. Now kindly read 266(2) once. The commissioner, if my lord is 266(2), my lord,
Yes.
the commissioner may make an order under subsection 1. Lord, it has to be read. Notwithstanding the fact that the assessment of such building has been made for the levy of the property tax. So here also it says that the commissioner may pass the order. Then 3, any person aggrieved by the order of the commissioner made under subsection 1 may within 30 days from the date of order prefer an appeal against the order. Then 4, where an appeal is preferred under subsection 3 against an order made under subsection 1, municipal building tribunal may stay the enforcement of the order on such terms. Then my lord may see, my lord 6 also. Every order made by the municipal building tribunal on appeal and subject to such order, the order made by the commissioner under subsection 1 shall be final and conclusive. Whereas 7, an appeal has been preferred against the order of the commissioner under subsection 1, or where an order or subsection has been confirmed by the appeal, whether or without modification, the person against whom the order has been made shall comply with the order within a period specified therein, as the case may be, within the period if they fixed by the municipal building tribunal on appeal, or failure to do so within the order, such period commissioner may himself, not kindly read 7 with 1. So suppose not kindly take a situation that the executive engineer passes an order of demolition. I go up to building tribunal. Building tribunal modifies the order, gives me a certain time. Here it says the commissioner himself has to extend it. So if a subordinate passes the order, how can he extend it? But the power to pass an order of demolition, if we read the entire section, but I am again placing subsection 7, kindly allow me to do that, where no appeal has been preferred. Suppose no appeal is preferred against an order made by the commissioner under subsection 1, or where under subsection has been confirmed by an appeal, whether with or without modification, the person against whom the order has been made shall comply with the order within the period specified therein. So suppose commissioner has given 15 days time. I didn't prefer an appeal. Or as the case may be, within the period, if any, fixed by the municipal building tribunal on appeal, and on failure of such person to comply with the order, within such period, the commissioner may himself cause the demolition, cause the building or the work to which the order relates to be demolished, and the expenses of such demolition shall be recoverable. So the demolition has to be done by the commissioner himself. So if we then kindly take, Lord, Subsection 8 gives the power to the mayor in council to pass an order. My lord, it's like 208 subsection 5, my lord, like 400 subsection 8, and emergency power has been conferred under the MIC. It's not a case under my lord, 266.8. My lord, it is a case under 266.1. Now, my lord, kindly come to section 47, on which Mr. Bhattacharya was relying on for the corporation.
Yes.
Delegation of powers and functions. The Board of Councillors may by resolution delegate, subject to such condition as may be specified in the resolution, any of its powers and functions to the mayor in council. So one is BOC to MIC. Then 2, the mayor in council may by order delegate, subject to such condition as may be specified in the order, any of its power and functions to mayor or the commissioner. But kindly pause here for a moment. BOC to MIC, MIC to mayor or commissioner, there is no standing order required. Then kindly read subsection 3 of 47. Subject to such standing order. This subsection has been made subject to the standing order which is passed by the mayor in council. Subject to such standing order as may be made by the mayor in council in this behalf. Then kindly read B. 47.3, not
Yes.
47.3, it starts with subject to the standing order. Corporation has not disclosed in the affidavit any standing order. But subsection 1 and 2 doesn't talk about any standing order. So whatever power the commissioner will allocate, that is subject to the standing order. Standing order as may be made by the mayor in council in this behalf. B, the commissioner may by order delegate, subject to such condition as may be specified in the order, any of his powers or functions as any other officer to any other officer or an employee of the corporation. Lord, this is a general power of delegation subject to the standing order. 266.1 deals with the power of demolition, which says that the commissioner can delegate.
If I take your argument, Mr. Chakravarti,
My lord.
then 266.1
Yes.
is not something which can be delegated. Only the proviso can be delegated.
Yes.
That is your
That's a
argument?
substantive power under 266.1. Yes.
That is
Yes.
what your argument.
Yes.
You are arguing that 266, the proviso 1 and proviso 2 can be delegated to the special commissioner.
Yes.
Right? That is your argument.
Nothing else in 266.1. That's my submission. My lord, I'm grateful.
Not one. The proviso of 266. Not one, sir. The proviso of 266 only gives power to the special commissioner for dealing with 2 conditions, which are the proviso. Proviso
So
1.
cause and stop work notice, my lord.
Proviso 1 and proviso 2.
Yes.
But there is nothing which bars under section 266 to delegate the power to any other officer.
Lord, I am so grateful to your lordship. Lord, the law laid down by our honorable court in Moninuddin Bapari, Lord, 40 CWN page 17, Justice Asutosh Mukherjee's judgment, and it is being followed till date, which says a statutory authority can, there is a difference between a statutory authority and a private party. I can do what is not prohibited in law. They can only do what is permitted in law. A power of the.
That's what I'm saying. If I read it, I can read it that 266 allows the commissioner to delegate the power as far as 266.1 is concerned. Only restriction is to the proviso. This can also be a way of
Subject
reading
to
it.
correction by your lordship's, the law laid down by your lordship's court, lord, says contrary. It says that a statutory authority can do what is specifically provided in the
That's what I'm saying. It is specifically provided.
That means your lordship will supply causas omissus. Because that reading of your lordships, that is not barred, so he can do whatever you want.
That I have to decide. Show me the judgment.
Lord, I'm just making my submissions.
Give
Lord,
me the
obviously,
judgment, what you're saying.
I can only make submissions. Lord, I
Mr.
can.
Chakravarti, I'm saying,
the
give me the
answer.
judgment on which you're relying.
Yes. Kindly take, Lord, the first judgment, 61 Supreme Court 1170.
Give a copy.
40 CWN.
Readings are complete here, right?
Yes.
Filing my affidavit in opposition.
You have filed your exception?
Yes, reply. It's on a
Where's the
question of
reply?
law. I have raised 2 other questions of law. Facts are clear that there was no notice given to me.
Yeah, 61 Supreme Court.
Where is your
Supreme Court? 1170.
yes?
Lord, kindly take AIR 61 Supreme Court 1170, Lord.
Yes.
3 judge bench judgment.
Yes.
JK cotton spinning. My lord must have gone through it many times, my lord.
Yes.
Kindly take paragraph 9 and 10. What is to be done when there are two conflicting provisions? What is to be followed?
Yes.
My lord, kindly got that, my lord, para 9. There will be complete harmony. However, if we hold instead that clause 5A will apply in all other cases of proposed dismissal or discharge, except where an inquiry is pending within the meaning of clause 23. We reach the same result by applying another well-known rule of construction, that general provisions yield to special provisions. The learned Advocate General seem to suggest that while this rule of construction is applicable to resolve the conflict between the general provision in one act and the special provision in another act, the rule cannot apply in resolving the conflict between general and special provision in the same legislation. Here, like here, the suggestion does not find support in either principle or authority. The rule that general provisions should yield over to special provisions is not an arbitrary principle made by lawyers and judges, but springs from the common understanding of men and women that when the same person give two direction, one covering a large number of matters in general and another to only some of them, his intention is that these later directions should prevail as regards these, while as regards all the rest, the earlier directions should have effect. Then in so-and-so versus so-and-so, mentioned the rule. The rule is that whenever there is a particular enactment and a general enactment in the same statute, and the latter taken in the most comprehensive sense would overrule the former, the particular enactment must be operative and the general enactment must be taken to effect only the other parts of the statute to which it may properly apply. Then kindly read para 10, Lord.
Yes.
Applying this rule of construction, that in case of conflict between a specific provision and a general provision, the specific provision prevails over the general provision, and the general provision applies only to such cases which are not covered by the special provision, we must hold that clause 5A has no application in the case where the special provision, clause 23, are applicable. Now, what is the affidavit of the corporation? They don't say what is falling from your lordships under 266(1), commissioner had the power. They says commissioner has delegated under 47(3). It's not their case. So if 47(3) and 266, if 266 applies, that's a special provision. If there is a conflict between a special provision and a general provision, always, my lord, the special provision would apply.
But this is not, if you read,
my lord,
if you see their affidavit, anyway, they'll argue.
Yes. Their affidavit is that it is done under 47(3). I'll show that affidavit. I'll show that. My lord, may I show that affidavit there?
Whatever you want to show.
Yes. So, my lord, my first submission is 266 will apply, not 47(3).
The first submission is 266 will apply because the proviso 1 and 2 specifically mention that the special commissioner has power to deal with it. Right? The proviso.
Delegate, show cause, and
only the proviso.
Only the first and second proviso. So nothing could be delegated.
What about the section?
Not kindly consider this. If what is falling from your lordship is that there is no bar, then there was no requirement to give the third proviso that you allow this, you allow this.
No, because these are two aspects which have to be dealt. One
let us read
is show cause notice. The other is
let us read 266.
Notice.
Let us read 266 once. 3, third proviso. Let us take a situation that the third proviso is not there today. Lord, we are your lordship is interpreting a statute. Lord, I'm just with my limited knowledge trying to assist your lordships. Lord,
no, I'm not. I'm just applying myself, Mr. Chakravarti.
I'm only assisting.
I have not taken any decision. I'm just debating with you.
My lord never does that. That I know.
This is a view.
My lord never does that. Lord, your lordship is speaking your lordship's mind. That is beneficial to us. We can counter and give a counter argument.
The reason why I'm speaking. Otherwise, if you want, I can just listen to you.
Lord, we feel very, Lord, that is the comfort here when we argue the case. But kindly take the third proviso.
Yes. Yes.
Lord, first and second proviso says what is to be done. Third says how it is to be done. First proviso says you have to issue a show cause.
Yes.
Second proviso says you can issue a stop work.
Yes.
Third says how it is to be done. Lord, let us take a situation. Third proviso is not there today.
But this is what
Lord,
I'm saying.
Lord, I'm trying to make a submission. Kindly consider
I'm just
this.
asking one question.
My lord.
That this only is dealing with the proviso. But
Yes.
as far as 266 itself is concerned, you can't read. The section is also there.
Section says commissioner has to do it.
The commissioner has
So
to do it.
then he has to.
So, yes, that's what I'm saying. That's right. So when you are saying that the commissioner has to do it, then 47 comes into play. 47(3) can apply. This is just.
No, yes. My lord, kindly. Yes.
I'm just a counter argument.
Of course, my lord, of
Yeah,
course.
just
of
saying
course.
that this can also be one of the arguments. That 47(3) will
That's
apply.
their only argument. And 61 Supreme Court takes care of that. When there are two provisions, you cannot rely on the general provision. Special will prevail. Lord, on this ground, I'll take another one. 2019 5 CHS SCC 480. Lord, this is.
Yes.
Lord, this is Justice Nariman's judgment.
Yes.
Kindly take note, paragraph 23. Sorry. No, para 63. I'm sorry, my lord. Para 63. 40 CW and unload. When one section grants general power as opposed to another section of the same statute which grants specific power, the general provision cannot be utilized. It says cannot be utilized, whereas specific provision has been enacted with a specific purpose in mind. So once 266 comes, you cannot rely on 47. Because otherwise, proviso 3 would be rendered meaningless. Why it restricted only to 2 provisos? Why it did not say that the commissioner can delegate anything? Why it did not say that the commissioner can delegate the power under the main section? Because main section is the substantive provision, 266(1). That says that commissioner has the power. It first proviso, second proviso says 2 additional that you have to issue show cause, you have to issue stop work. Third says you can delegate first and second. Let the show cause be issued by someone else. Let the stop work be issued by the authorized officer. But you cannot delegate the other portion. Then if we read 7 together with this,
Yes.
7 says, suppose today I have not come to High Court. I did not prefer an appeal. The commissioner has to himself take a call. Subsection 7, can you read it with me, Lord? It uses the term commissioner may himself cause.
Yes.
So if we read this with the third proviso or the first section, subsection 1, that means the commissioner himself has to pass the order. Now, my lord, with your lordship's, my lord, I'll just find it, or just give me a second, my lord. I'm not carrying Moninuddin Bapari. I have asked for it. Just, my lord, give me a second. I'll just take it out from the SCC online. That's a settled law, that whatever is my lord knows, my lord is testing me, my lord, whether my lord knows this judgment. My lord must have been shown this. Moninuddin Bapari many times by the bar, my lord, 40 CWN, that whatever is specifically provided in a statute, nothing else could be done. Either you do it or you don't do it. You cannot say that its statute is silent, so I'll do it. On the contrary, my lord, kindly recollect Maneka Gandhi's case, my lord, the passport matter. The Supreme Court says even if the provisions of natural justice is not given, you have to read it into the statute. But when you are taking a call that you will demolish someone else's house, you cannot usurp a power which is not given to you. You have to apply that power which is only provided in the statute. Kindly give me a minute, I'll just find out that judgment. কি হলো বইটা এলো না বার থেকে? Just give me a second. PCW টা আনতে বললা Yes. Lord, Justice R.C. Mittar's judgment, Justice Lord, I could find it out from the Indian Kanun. I'll supply your lordships. I have asked for the book. I'll read the relevant portion only. It was also a municipal matter. I'll only read the relevant portion. Para 8. It is a fundamental principle of law that a natural person has the capacity to do all lawful things unless his capacity has been curtailed by some rule of law. Like me, I can do whatever is not prohibited in law. It is equally a fundamental principle that in case of a statutory corporation, it is just the other way. The corporation has no power to do anything unless those powers are conferred on it by the statute which creates it. I'll have a look at it.
No, I follow it.
So 266(1) does not say that the commissioner can relegate his power of passing an order of demolition. It says that two provisions only could be delegated. Nothing else could be delegated in my humble submission. Then Lord, kindly take. Lord, my learned friend has taken a point that I have not pleaded this in my writ petition. Before he takes that, I need to deal with that. My Lord knows a pure question of law which goes to the jurisdictional issue can be taken up at any stage. If my Lord wants, I can cite my Lord MP Power 2021 4 SCC 548 or 2019
Legal
7.
argument, whatever legal argument.
Yes.
What is the legal argument?
I'll take this to my Lord on a question of law can be taken up at any stage.
Yes.
Since my learned friend has taken that point, it's my duty to cite. 2021, my Lord need not read, just mark the paragraphs. 2021, 14 SCC 548, para 14. And 2019, 17 SCC, page 82, para 17. Both the এই তো বললাম তো 2021 14 SCC 548 and 2019 17 SCC 82. In both the judgments, my Lord, the Supreme Court says that a question of jurisdiction, if my Lord takes up the 2021, takes the last page of the judgment, takes the last page of the judgment, my Lord, page 556.
Yes.
But kindly take the second sentence, speaking for the court. My Lord has kindly got that. Speaking for the court, Rohinton F. Nariman J. held that if there is inherent lack of jurisdiction, the plea can be taken at any stage, and also in collateral proceeding, he highlighted the well-established principle that a decree passed by a court without subject matter jurisdiction is a nullity, and that is invalidity could be set up whenever and wherever it is sought to be enforced or relied upon. Such a defect of jurisdiction cannot be cured even by consent of parties. The above dictum would apply to the present case. So this is one limb of my submission. My Lord, there is another limb if my Lord takes up the impugned order once in the writ petition. My Lord will get that, my Lord, at page 20. Apart from the case of jurisdiction, my Lord, I have taken two more points which I am trying to canvass before your Lordship. My Lord, this is a longish order. My case before your Lordship is that I am the mother.
Page 20 of the writ petition.
Page 20 of the writ petition, 20449. Take 20449, my Lord. Where is it?
Yes.
Lord, my Lord has kindly got that. My Lord, apart from the point of jurisdiction, the writ petition was filed also taking the point of violation of natural justice. My Lord, in page 19, I have given a typed copy on the last occasion. I have annexed, my Lord, the record of rights, where the petitioner's name has been recorded as a Rayat. Rayat means the recorded owner. My Lord, no notice of hearing, no notice of demolition, whatever has been served on me. Lord, I say that the building, the subject matter of the writ petition is not an old structure. Lord, Nuruddin house, Lord, the entire area is known by the name of Nuruddin, my great grandfather-in-law. Lord, he was a big businessman. He established many houses there. The road is also named after him. This outhouse was constructed long time back. And I shifted post 2020 COVID. Lord, after death of my husband, I had a conflict with my daughter-in-laws. I shifted to that house. No notice ever has been given to me. The corporation says that riot doesn't mean that I am the owner, so I need not have served any notice. This is the second ground of violation of natural justice. And the third ground that I have taken, there is no demolition sketch map or demolition précis has been supplied with the order of demolition. Which portion is illegal? What is to be demolished?
They are saying you don't have a sanction plan.
Lord, it's a very old structure.
Then everything is illegal.
They are saying there has to be, Lord, I will rely on a judgment called Laddu Gopal Bajoria for your Lordship's kind consideration. My Lord may have a look at that. Obviously, in that judgment, there was a sanction plan. 2 floors were legally constructed. But no, my Lord, kindly have a look at only one paragraph of Laddu Gopal Bajoria. Then my Lord sees that non-supply of demolition sketch map also violates natural justice. Kindly have a look at this.
In a case where there will be a sanction plan, sir.
Yes, but
not in a case where there's no sanction plan.
My Lord, I completely bow down to your Lordship, my Lord, but my Lord, the corporation
In this case, there must be a sanction plan.
I see, my Lord, there was a sanction plan.
Factually, it is distinguishable.
Yes. Absolutely right. My Lord is absolutely right. In Laddu Gopal, there was a plan. First and second floor was sanctioned, rest of the portion was illegal.
There has to be.
Lord, when I am relying on a judgment, it's my duty to say, my Lord, which portion is not
asking you, sir.
Why I am showing this? Why I am showing this?
When you read this order, they are saying that they have failed to submit any sanction plan. They don't have any building.
Demolition précis. Lord, what is to be demolition? How much is to be demolition? The building, where does it stand? Nothing has been there.
Mr. Chakravarti, this argument is too much.
Very well. I'll not stage that.
This argument
I will not stage that. Very well. I'll not stage that. I will not stage that. Very well. Take note their affidavit. Take note the affidavit of the corporation.
From you, at
Take
least
the
we
affidavit of the
expect.
No, I that's why I said that there was a plan in Laddu Gopal, my Lord. I said that. Kindly take the affidavit of the corporation once.
Yes.
So, Lord, I stand on 2 grounds: jurisdiction and violation of natural justice. Take, my Lord, the affidavit of the corporation.
Yes.
My learned friend's affidavit I am not relying on because he is supporting the order of the corporation. So he has only said that it is a good order. Lord, kindly take, Lord, paragraph 6 once.
Yes.
No, 8. Come to 8 directly.
Yes.
I state and submit that thereafter hearing notices were issued upon the Rukhsana Hamid. Rukhsana Hamid and Abdullah Jakaria and Suleiman Jakaria by memo number so and so. So admittedly no notice was issued to me. Then asking them to attend the hearing to the office of Asansol Corporation. Then we'll kindly skip over, kindly come to paragraph 9. Not kindly take the second sentence. In this connection, I state, my Lord, kindly got that? Para 9, page 5. In this connection, I state and submit that superintending engineer had passed the demolition order in exercise of the powers of delegation issued by the Commissioner Asansol Corporation, wide memo number so and so in terms of 47(3)(b). Yes. Now, if 47(3)(b) doesn't apply at all in view of 266, in view of the judgment of the Supreme Court, then this delegation could not have been passed. Then can you take one more sentence only? The next paragraph. The issue of non-service of notice upon Rukhsana Jakaria before the hearing of Asansol Corporation does not and cannot arise at all. The said Rukhsana Jakaria is not the owner of the suit property. The name may have been recorded in the LR record of rights, but it is the settled principles of law. Record of rights creates title, record, neither creates title nor extinguishes. Lord, kindly have a look at West Bengal Land Reforms Act, the definition of riot. Lord, I have not highlighted it. Just the definition of riot. I have been named as a riot in the ROR. Kindly seize, my lord. Rayat means a person or an institution holding land for any purpose whatsoever. Lord, I have marked the highlighted portion below the page. Lord, before amendment, it was only for the purpose of agriculture. 10, kindly read 10, Lord, at the footnote. So now, whoever is holding a land for any purpose is a Rayat. So I have some interest in the property. Corporation cannot say that they will not serve notice on me. Now, this is the affidavit of corporation, and if I may show the delegation, kindly take me not page 20. Sorry, page not
last page.
Page 13. Page 13. But it is a very fast reader, my lord. I am proceeding a little slow, my lord. Kindly come to page 13.
You have to read more. We have to read less.
Kindly come to para 13 once. Page 13. I Swanso, IAS Commissioner Asansol Corporation, exercising the power and functions of the Commissioner, confirming the relevant provision of the Municipal Corporation Act, due to my extreme preoccupation involvement in relation to the office matters, as well as affairs entrusted upon me by the government from time to time, do hereby delegate under 47(3)(b). It's not a delegation under 266(1). But these are my submissions, my lord. This order should go. Lord, I am ready to face any proceedings. Let the Commissioner pass the order. These are my submissions, Lord. I'm grateful to you, Lord.
Yes.
Two or three things. First of all, my learned senior friend had placed Millard the definition of Rayat. She may have Millard some interest in the land, not the structure. Therefore, that definition does not come in the help of. I am not Millard on the unauthorized construction of a land. I am on the unauthorized construction of a structure.
Absolutely.
Who is the Millard petitioner herein? Petitioner is the son of Suleiman Zakaria and the Millard, the other person Millard against whom Millard demolition or the what is the name? Abdullah Zakaria and Suleiman Zakaria.
Yes.
They, my lord, attended the hearing.
Yes.
My lord has seen they were asked to produce the sanction plan. Could not. Now, my lord, when my lord to avoid my lord to that they are silent, they have my lord produce their mother my lord in the front and say you challenge it. My lord, this is the tactics they are taking. One. Now, my lord, record of rights, my lord has seen, my lord, definition of right. It doesn't say, my lord, LR record by the block land and land reforms officer. He has a, my lord, interest, my lord, in the structure. No, that is not. When it is recorded in the records of the corporation, then for the purpose of assessing tax, then I could have understood, my lord, that this lady, my lord, the writ petitioner has interest in the structure. Therefore, my lord, giving notice to that lady, my lord, does not amount to, my lord, violation of principles of natural justice.
Yes.
One. Number two, my lord, kindly, my lord has by this time, my lord has seen, my lord, the order of order, my lord, of delegation, my lord, being at page 13 of the affidavit. My lord, this is, my lord, as a standard procedure, my lord, we are doing because, my lord, the commissioner is otherwise, my lord, engaged, my lord, it's so many works. Everything, my lord, kindly, lordship will see all the provision commissioner will do. Whether my lord it's assessment, whether my lord demolition, everything. My lord commissioner, my lord, he is the head of the administration, every provision. If my lord he has to look, my lord, in a pass every order, pass every my lord show cause notice, every my lord demolition order, check it, sign it, my lord virtually my lord is impossible for the my lord. That's why my lord 47 my lord 3B my lord was enacted. My lord, this is a standing practice, my lord, which we are my lord following. My lord, and other matters, my lord has also seen, my lord, one Mr. S.N. Mukherjee was appearing with the last week, my lord, same order, my lord, we have passed, we have followed it on the same way. My lord, this is the thing. And my lord, kindly see one thing, my lord, as an officer of the court, my lord, section 47, if your lordship would kind enough to see, 3B, it says, my lord, standing order. Lord, that, my lord, I cannot show, my lord, lordship, there is any standing order of your accounts.
What is your argument for that 266 proviso 1
no,
and
266 proviso, my lord, definitely it can, my lord, delegate to special officers appointed by the government. But whether once 266 main act says that the commissioner can pass a my lord, order of demolition, my lord, that is subject to my lord, correction by your lordship. 3B, my lord, qualifies it. kindly see, the commissioner may by order delegate subject to such condition as may be specified in the order any of his powers. Now, any of his power also may not include power of passing an order of demolition. This may not, this is may not, what is there?
Any judgment?
And Milord, I was Milord going Milord through Milord the judgment of which my learned senior friend was relying upon 61 Supreme Court. It was Milord relating a control order, not a statute. I was Milord quickly have a glance.
Anything else?
This is Milord. I cannot Milord approve Milord beyond my affidavit. Milord, this is the 47(3)(b) we are following in these matters.
Well, I have only for submission. So perhaps regarding the status of this writ petitioner, she is saying that she is a riot, but Supreme Court in category of judgment categorically stated what is submitted the revenue record of right that cannot be treated as the ownership of any particular property.
That is the point I have also done. Neither creates title nor extinguishes.
And second point, my lord, kindly see page paragraph 11 and 12, relevant portion, my lord.
Whole complaint.
Furthermore, the High Court committed in error is also throwing the burden of proof upon the defendants, appellants, without taking into consideration the provisions of Section 101 of the Indian Evidence Act. In Narayan Prasad Agrawal versus Ehlers versus State of MP 2007, this court opined, record of right is not a document of title. Entries made therein in terms of Section 35 of the Indian Evidence Act, although are admissible as a relevant piece of evidence and and some as a presumption of correctness, but it is beyond any doubt or dispute that such presumption is rebuttable. The first point. Second point, my lord, they have categorically stated in a writ petition that he has no connection with the unauthorized construction. Now, you can see for a moment, page 24, paragraph 6. What they have stated.
Page? Where are you?
Page 24, paragraph 6 of the writ petition.
The writ petition number, which one?
20449.
Para 24.
24. Page 24, para 6.
Para 26.
Page 24, para 6.
Purported of 5A of the government order.
It is a representation, it starts from page 20.
Yes.
The representation they made to the Association Municipal Corporation. Thus you can see that it is pertinent to be mentioned that my sons, namely Abdullah Zakaria and Suleiman Zakaria, has for a long time now stopped all sorts of communication with me, and as such has never informed me about such acts of illegal construction or any proceedings before the Association Municipal Corporation. She has no connection with the unauthorized construction, did not give her consent. If it is so, my lord, they kindly see Section 266 itself stated. I am reading my lord explanation only. We have already submitted for lordship. The explanation says, in this chapter, the person at whose instance shall mean the owner, occupier, or any other person who causes the creation of any building or execution of any work to be done, including alteration, additions, if any, or does it by himself. When she herself states, I have the connection with the unauthorized construction, how she is aggrieved and how she can expect the notice to be served upon her. Section very clear on this point, my lord. That is sufficient, my lord.
There is nothing to reply.
Heard.
I'm grateful to this. Lord, the interim order would expire on 15th of October. My lord, may
15th.
extend it till disposal of the
Have not touched the building, will not be. So long matter is waiting, nothing will happen.
Order will come before that.
No, no, that I know. But some order, my lord, may have passed today, my lord.
For what?
Let it continue till your lordship decides the matter.
It will come.
Yeah. CAB.
But I'm grateful to you.
If you have this.
Much obliged. বইটা দেবে দিয়ে দিচ্ছি নাম দিয়ে দিচ্ছি Lord, both the writ petitions my lord will deliver judgment. Lord, Moniruddin Bapari, I'm giving you lordship the printout by today, Lord.
एक line add कर दो, interim order till the disposal of the present writ petition.
Hello?
Interim order till the disposal of the present. That's what you want?
Till delivery of.
That is going back with something.
Till delivery of judgment. That he wants.
I'm for the petition. Item number 5.
सारा उसमें डाल देना entry model till the final disposal. Entry model shall continue till the final judgment in this order. Arguments heard, concede.
The mediation failed.
Mediation failed.
Mediation failed.
Hmm.
At the instance of the petitioner in item number 6.
Any report? ये क्या है?
My lord, I had already applied, but it has not yet been received.
I'll come back after 5 minutes. Lost. Yes.
This matter I already placed before your lordship. The West Bengal Municipal Employees Date-cum Retirement Benefit Rules 2003. Here the rules specifically states that the family pension must go first to the wife. That means the widow. My lord, I have already handed over in the earlier occasion, my lord.
Yes, right.
My lord. That is the page 6. First is 13.
The replies have not been called for right now.
No, my lord.
So one is the petition filed by you.
And another is the mother-in-law of the petitioner.
Lordship, I am the petitioner in item number 6.
Item number 6.
Lordship.
What was the nominee regarding the nomination as per your lordship's
So
observation?
in item number 5, you are the
I am the widow.
You are the wife. And you are the mother-in-law.
Lordship.
And both of you are claiming retirement benefits.
The benefit, what about the nomination? The nominated amount was the gratuity, provident fund, and allies, rather than the pension, family pension. That had also already been adjudicated by the under district delegate, and 50% has been allocated to me, and the 50% allocated to the nominated person, that is the mother-in-law of mine. That has been adjudicated. Here, my lord, what the petitioner in item number 6 is claiming the pension, family pension. But what my submission is that family pension, as per the rules, goes to the widow.
You are in item 22817.
My lord. My lord.
You are also asking for the same thing, family pension.
Asking for family pension. I am the legitimate one. As per the rules, my lord. My lord, kindly come to page 7, my lord. Sub rules, rule 17. May I read, my lord?
What are you reading?
Page 7 of the rules, my lord. Rule 17. May I read?
Yes.
Subject to the provision made under Rule 19, the family pension shall be admissible A, in case of widow / widower up to the date of death or remarriage, whichever is earlier. B, in case of minor son until he attains the age of 18. In case of unmarried daughter until she attains the age of 21 years or marriage, whichever is earlier. In case of dependent parents up to the date of their death or remarriage, whichever is earlier. But there is also a note. Where an employee is survived by more than one widow, the family pension shall be paid to them in equal share in regards to the widow matter. Well, then kindly come to Rule 19, my lord. Subject to the provision contained in the note of Rule 17, the pension awarded under these rules shall be payable to more than one member of employee's family at the same time. It shall be first be admissible to the widows / widower, and then to the minor child, and thereafter to the mother, and lastly to the father. In the event of remarriage or death of the widow / widower, pension shall be granted to the minor child through their natural guardian. In disputed case, however, the payment should be made through a legal guardian, my lord. But the rules clearly states that the widow is the entitled one of the family pension. And on death of the widow.
All right, take down. Let them file their replies now. File your reply. You appear for Bhatpara municipality.
For the state.
Who's for the Bhatpara? You are for? Who's for Bhatpara municipality? Who has been appearing?
In the earlier occasion.
Chief Shankar Banerjee.
Chief Shankar Banerjee. But in the earlier occasion, they are also submitted what my lord gives the direction, they will follow. That is their view.
So whatever they'll, without their affidavit, how can we give any direction, sir? Their stand has to come.
But then kindly direct the minister to disperse already what has been adjudicated by the landed district delegate. Because I am
Nothing doing now.
I am suffering from 2017 till
Both,
now, my lord.
both of you are suffering, you should suffer more. Suffering is both. Wife, mother-in-law, everybody.
Mother-in-law
Just take down.
has accepted the claim, my lord.
The petitioner in the present writ petition, both the petitions are taken up for hearing together. Full stop. The petitioner in WPA number 22817 is the wife of the deceased. What was the name? What?
Poonam Kumari.
Deceased.
Naveen Gope.
Naveen Gope, who was an employee of Bhatpara municipality. Full stop. He deceased on?
In the year of 2017, my lord, kindly. 23rd March 2017.
He said employee deceased on so and so date. Full stop. The writ petition, the petitioner has preferred the present writ petition seeking dispersal of family pension to the petitioner with arrears of interest. With arrears and interest. Full stop. The other writ petition 22 writ petition 5755 has been filed by you are the
Lordship, I am the petitioner, the mother-in-law. Sorry, the mother of the deceased.
that's what the so and so is filed by the mother of the deceased claiming to be the legal heir and entitled to receive the pensionary benefits of her son, of her deceased son, so and so. Full stop. She claims the release of, in the present writ petition, she claims the release of pensionary benefits in her 50%. 50% of death benefits, including family pension, with arrears and interest in her favor. Full stop. None appears for the Bhatpara municipality. The Bhatpara municipality is directed to file their affidavit in opposition within 3 weeks. Reply to the same, if any, within 1 week thereafter. Is the state required? No.
Because the concerned person for disbursing the pension is the chairman, as per the rules.
Let this matter be listed after 6 weeks.
Kindly fix a date, my lord.
15 September.
Deeply.
Yes, Mr. Chaudhary.
Well, if your lordship takes a strict view, my client will go to jail.
That's what I was telling her.
Yes.
My lord, when they came to me, my lord, I got to the bottom of it. And there is, my lord, the client's mother, she was a minor then, I think has signed. And I'll tell your lordship what happened. But I've got all the original documents. None of it is there, my lord. I'll just show your lordship the whole thing. Then if your lordship feels they should be let off, your lordship will. Otherwise, whatever your lordship feels. My lord, she was born in Howrah, under Howrah Municipal Corporation. And my lord, the date of birth is 20th of May, 1995. 16th May, 1995. The Howrah Municipal Corporation, before that, the hospital, my lord, gives that first document which you have to take. That is at page 22. This is, my lord, 20th May 1995. So 4 days after she was born, on 20th May 1995, this is, my lord, the document that was issued. Now, my lord, based on that, this document, this is from the hospital. This is the procedure is you take it. Now, my lord, all modern hospitals, they send it themselves directly to KMC. But when we were born, my lord,
we had to take
you had to take it. So you take it. Howrah Municipal Corporation enters it in a birth register. Now, birth register at that time, you can get an extract of the birth register under section 12 of the Act.
Yes.
Extracts of registration entries to be given to informant. This is the, my lord, the Act, and this is the extract. So this is genuine. Now, when she goes to school, give all the school originals. Lord, when she goes to school, she uses these, which is, my lord, normal, because it's my lord, this is, she went to a school in Howrah, St. Agnes. This is her, I don't know, the mark sheet.
So her name changes from Achal to
Yeah,
Sakshi.
that is fine, my lord, because that I have seen. That's on 22nd. Now, 7th November 1997. Name changes from Achal to Sakshi.
Yes.
That affidavit is also here.
All right.
Please see this. This also refers to the birth certificate. This is the affidavit. Up to now, there is no problem. Problem is when you don't do something in the proper way.
Yes.
Milord, her Montessori document we have annexed at page 25. This is the Montessori document. Shows, my lord, 16th May 95, the appropriate date. Now, my lord, what happened was, when they went, my lord, this was in the 90s, my lord, it was, Howrah Municipal Corporation was not what it was today. My lord, computerization, I don't know to what extent had happened. When she was a minor, they went to apply for a passport. Must have gone to one of these touts. Must have been advised by the tout that you get a document. I'll get everything done. That is when an application was made to the Kolkata Municipal Corporation. And this I found out. Passport though. Yes. This is the photocopy of her passport. Milord, please see the first page. It's issued, old passport, this is the new passport.
Yes.
It's issued, Milord, on 14th October 2008. Kolkata Municipal Corporation birth certificate is, Milord, issued on, where is that? Issued on 19th 18th August 1998. So 2008 10-year passport will possibly. No, this is no. To me, dekhale amay konta. No, I'm sorry, Milord. I showed the wrong entry. Please come to the last page. Last page, Milord.
Yes.
Second last page. Date of issue is 18th November 1998.
Yes.
So, Milord, when she wanted a passport, she went to Kolkata Municipal Corporation and she applied with a date of 16th April 95.
95.
There's a 1 month discrepancy. So this is the first wrong. Her mother signed it. She didn't do it herself. Her mother did it. So today you have a passport with a different date of birth. And I asked her also that, why did you go? The reason is, when she came of age, when this passport expired, when you apply for renewal of a passport, there is a column which says that if there is a discrepancy, then you will inform of the date of birth, etc. So, my lord, it expired 7th April 24. So when she applied for a new passport, this time as a major, she's 30 years old, she's married, she's working somewhere. So when she applied, she put in the correct date to correct the date in that discrepancy column. So immediately, now passport authorities are very, very good. They immediately made inquiries and traced it out. Which is why she went to Kolkata Municipal Corporation to have it corrected. They refused to correct it because how can you correct it? Then she filed this writ petition, and here we are before your lordship. So this is, when they came to me, I said that, look, first criminal offense is by your mother. When she is alive till today. Because she is I'm told, Milord, she signed on the KMC documents. That's a criminal offense because it's a
You have declared.
misstatement,
Yes.
wrong declaration. Don't continue. Go clean. So this is what has happened. Your lordship wants, I will, Milord, ask her to be present on the next day. Ask her mother to be present on the next day. Bring an affidavit disclosing correct facts. And then request for your lordship's kindness because her life will change, Milord, if this Milord goes. She's working somewhere.
But Mr. Chaudhary, the problem is that her passport will be also cancelled.
Everything will go. She lose her employment also. She lose her employment also. Passport is anyway gone. Now, I really don't know how to solve it. So these sort of situations.
Declaration of fact cannot entitle her to any sympathy from the court.
I know. But will I perpetrate further wrong by trying to hide from your lordship? I will
Because
not.
even I had thought that I'll pass a direction for the police to inquire into it. That's what
Not required. I am here. I will tell your lordship the truth.
If she was there last time, I made it very clear that I'll pass a direction.
This is what has happened. Lordship can still pass a direction. I am not opposing it also.
No, but if I pass a direction, she is in trouble.
She'll be in trouble. But this is what has happened. I can, Milord, file an affidavit, Milord, indicating all of this.
It will not help.
Now, question is, Milord, a girl, Milord, when she's a minor, this has happened. She has really, apart from affirming and a writ petition, she has really done nothing wrong. Mother did it. Some housewife. Problem is some people have this mentality. I'll get it done easy way through tout without understanding what you're doing. So this is what you have done. So now this is what I've explained to her. Number one, you will lose your passport. It's a mistake. It's an offense under the Passports Act. And it's 5 years minimum
yes.
compulsory punishment. So who's guilty? Mother. Is it lady? Whatever. She's guilty. So that's number one. And it's 5 years plus fine. It's a non-compoundable offense. Number two, it's a misdeclaration to the Kolkata Municipal Corporation. Number three, now that you know of it, you filed a writ petition and you've just asked for correction, but cancellation. But then, all of this should have been there according to me. May I just request your lordship to take it after 15 days? Your lordship will be less angry then. But at least my duty is to tell you what is the correct situation.
But whatever may be the situation, your lordship.
No, I am not.
We cannot cancel.
No, don't cancel. I'm not.
Petition has to be adjudicated in the light, my lord.
Correct. I totally agree with you. But people have to understand that you can't lie to court and to authorities. And there is a consequence for that.
We'll have it after.
But after the 26th, Millard, I'm not there for a brief period of 5 days.
All right.
Lord, kindly record an order that these documents have been placed before your lordship.
Let's not record anything.
Best is not to record.
Give it back.
This is by far, Millard, one of the most bizarre matters which have come to me. But what do I can't think of a way out.
She has literally ruined her daughter's career.
Yes.
All these misdeclaration and
Millard, one. See, you don't
website,
understand. When you go to a tout, he tells you, "Aur ek birth certificate ke liye apply kar do." You do it like a fool. You go and sign in corporation. You don't know what you're doing, how much of an offense it is. But it is an offense.
So you sit with that rather than, attracting more penal provisions against yourself. Why do you want to even pursue this? Why do you want to pursue this?
I don't want to pursue it. I have to come and tell you.
You withdraw this writ petition.
I'll withdraw
walk away. Walk away before we do anything. Learned comes for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
I'm grateful for
Mr. Chaudhary, then
I know if it's before you
order, then
you what to do?
I've forgotten.
Yes, I'm grateful.
Forget. She has done enough harm to herself.
Yes, let her roam around.
Let me not do any more harm.
No, I'm grateful.
Hello, I'm appearing on behalf of the petitioner, my lordship. In this matter, I'm appearing on behalf of the municipality, lordship. Lordship, I'm not getting any. I have not received any instruction. I'm telling for only
a copy.
Only not today, lordship.
You have a copy of the writ petition.
Similar order has been passed.
Tomorrow.
Not today.
And I'm the petition. I'm not led by Mr. Saptanshu Basu. I'm for the respondent. This is not under Asansol Municipal Corporation. So the West Bengal Municipal Corporation Act 2006 will apply. We have challenged an order passed by the corporation by which they have asked for passed an order for demolition. The principal ground is that this is a factory which is run by us from prior to 2005. Initially, it was under a municipality, Jamuria municipality, subsequently subsumed to the corporation. Under the municipality, we got the plan, site plan approved, building permit given.
and my lord, we constructed a plan. Subsequently, my lord, we had to, my lord, expand the plan. So by that time, my lord, initially the prayer was made before the municipality. Then, my lord, it came under, my lord, the development area, Asansol Durgapur development area. So we had to ADDA. So we had to take, my lord, permission under the West Bengal Land Development Act, my lord, for, my lord, development. Because apart from, my lord, plan, we have to take permission of the ADDA, the development authority also. That was applied for, that was granted. We had to pay a huge amount, my lord, for development fee to the tune of 36 lakh and odd. We paid that, and then we submitted, my lord, plan for expansion before the corporation. But can my senior take it?
Absolutely, Mr. Bas.
Development fee ta diyeche obdi boleche. Oটা দেখিয়ে দেবে development?
My lord, kindly take trouble to see the Municipal Act 208.
Which one?
West Bengal Municipal Act.
Corporation Act. Municipal Corporation.
2006.
6. Corporation Act. আমাদের হচ্ছে
6.
70. 270.
Which section?
278.
Yes. Or deemed sanction.
It's application dekha. Application dekha. Application.
63. 63 is the reply. এখানটা 63 থেকে শুরু হচ্ছে। কি 6টা জায়গা বলি? 63টা কে দেখি। 3তে ওরা চিঠি দিয়ে চাইলো ডকুমেন্ট। হ্যাঁ, ডকুমেন্ট এখানে তো প্ল্যানও দিয়েছিল।
In response to my letter,
Yes.
kindly come to page 63 first.
Page
63.
Annexure R.
Yes.
I have applied for sanction of building plan. To that, my lord, this is the answer. It asks for these documents.
Date.
Can you see the date?
8 July.
8 July 2019.
Where do you get the date?
At the top, 8 July 2019.
Yes.
We supply the documents.
These documents we have supplied.
It is in continuation of our application for sanction.
Yes.
Now, my lord, then kindly come to 65. We filed an application for sanction. They asked for certain documents, we supplied. Then, my lord, 65. As per above, it is our request to please approve layout plan of our integrated steel plant situated at Jamuria. It must be noted that our old plan has already been approved by the Jamuria municipality.
The original plan.
Now, kindly come to 66.
Okay.
Because to invoke, my lord, the provision of deemed sanction, I have to give a reminder to them. That reminder I have given.
Date 27 September.
That is, my lord, at the top, 27 September 2019. We carry on one.
পড়ে দাও।
My lord, second paragraph or the entirety, my lord, kindly read it.
Subject.
As per above, request for deemed approval of layout of factory plan. Has my lord kindly got it? My lord. As per above is our request to please approve layout plan for our integrated steel plant situated at Jamuria as soon as possible. It must be noted that our old plan has already been approved by Jamuria municipality. It must be noted that the approval of same is pending since long, and in spite of our continuous follow up and submission, we have not been given the final approval and is pending for an unreasonably long period, which is severely impacting our operations at the site. Therefore, we hereby request that if our layout plan is not approved within 30 days from the receipt of this letter, it shall be deemed approval as per the applicable regulation, and we shall proceed with our
Planned operation
and construction activities accordingly.
Yes.
This is demand. এর সঙ্গে কোনো সম্পর্ক নেই।
তারপর না রিভাইজ ডিমান্ড করলো ওরা
That is demand.
After construction.
Now, my lord, up to that, my submission is, in accordance with the provisions of the deemed sanction, I have given all documents which required to be done and also given a notice that if you don't do it, it's deemed sanction. Then, my lord, after construction, we have quite the construction. Page 67.
Revised demand.
Revised demand for property tax. Presumably, they have inspected the building after construction and revised.
হ্যাঁ তারপরে ইয়ে পরপর দেখিয়ে দাও তারপরে বললো যে অ্যাপ্রুভাল কোথায় আছে জিজ্ঞেস করলো 68
Then, my lord, if you also kindly come to page 68.
আমি উত্তর দিলাম 69 এ প্ল্যান চাইলো
Yes.
Then, my lord, kindly come to next page 69. Reference has been made with the above mentioned letter. In this regard, as we suggested, in this regard, we wish to mention that the plan has been sanctioned and demand was raised. But the demand was for complete factory instead of expansion part. We have requested for the contracting authority to revise that as soon as possible. But this was going on, then my lord impugned order. Order page 74.
পেজ 80 হচ্ছে ইমপ্লিমেন্ট হলো তার আগে আর একটা অর্ডার দিয়েছে
74 is down. Kindly come to page 74.
প্রিভিয়াস
Page sale, our construction report.
Yes.
74, my lord, kindly come, page 74. This is an order dated 11th December 2023. Now, this is suo motu proceeding. The contention is that without obtaining any building plan from the Asansol municipality, you have constructed.
Yes.
My lord has seen that. Then, my lord, they again sat tight.
Violation of building.
Then, my lord, again sat tight. Then, my lord, again the order dated 1st July 2025. Page 80.
ঠিক আছে তো দেখুন
Is that you have not complied with the order dated 11th. Just now I have placed before my lord to comply with the order. That's why they were supposed to come on 5th July 2025 at 12 noon. What they did, they came. Next is very important. On that date, they came. They asked for demand of rupees 20 lakhs. And direct give us a number of the account which is appearing that it is a number of Asansol Municipal Corporation General Fund, page 87. They have not taken cash, my lord. They have asked me to deposit in the corporation account.
Under what head? Is this for property tax or for?
This is, my lord, I don't know. They have asked for this amount. In lieu of that, they will not touch our building. That is the conversation there. I am not saying anything about that. They only asked me the amount to deposit in the account of the corporation. We have deposited.
See, there are two pending issues.
This is, my lord, the situation today.
No, Mr. Basu, there are two pending issues. One is your property tax demand, and the other is the issue of unauthorized construction which they are raising. So this 20 lakhs is taken on what?
Nobody knows. At least it was not disclosed to us that it is on the basis of the property tax. Now, my lord,
সিটি করেছে
টাকা চেয়েছে দিয়ে দিয়েছে আমরা কত ভালো
5th জুলাই সেদিন ওরা এসেছিল
how good we are, can you see?
ডেটটা ইজ ইম্পর্টেন্ট 5th জুলাই এসেছিল 5th জুলাই টাকাটা নিয়েছে
Then that date, 5th July itself, there is a notice that you will come. They came to my premises, asked for this amount, we deposited in the account. My lord, my case is, my lord, based on this is a huge factory. It was continuing. There was an extension of the factory. Factory is running. My lord, we have taken the permission from the ADDA also. If we want to do anything in that area, this is under the Asansol Durgapur Development Authority.
Page 54
Under, my lord, the
54 টা দেখিয়ে দাও তো টাউন এন্ড
Town and Country Planning Act that has been established. We have to take the permission from them. we have deposited, my lord, at page
54,
51,
54,
near about 31 lakhs
36,
36 lakhs and all. We have granted
for
everything.
development.
Now, only point is before, my lord, whether I am coming under the purview of 2078 or not. If I am coming under the 278, my lord, is my case is I am coming, and I will rely on judgment of division bench of our High Court, which says that deemed sanction will apply in the event your construction is not infringing any rule. If your construction, you are taking the advantage of deeming sanction, but you are violating the rules, that is not permissible. Now, kindly see the judgment of your Lordship's Court reported in 1981, 1 Calcutta Law Journal 501. 501. Justice Chittatosh Mukherjee and Justice Sharma, who was subsequently was the Chief Justice of our High Court. But at paragraphs 5 to 9, if you lordships kindly read, the entire judgment is based on that. This is coming from a suit court. That's why that part is also there. But relevant portion so far we are concerned, my lord, paragraph 5 onwards. And before your lordship read that, kindly keep in your lordship's mind, there is no allegation that we have infringed any building rules. Oh, I the Korai
building track, lake track. তুই কোনো বই এনেছিস? ঠিক আছে, অর্ডিন্যান্স জাজমেন্টটাতে একটা জায়গায় বলা আছে না যে এটা হচ্ছে কি ডিম স্যাংশন, যাতে কনস্ট্রাকশন করতে পারে।
जी पहुंचे संसद पहुंचे
পৌঁছে হাওড়া থেকে চলে যাচ্ছ, ওখান থেকে দিল্লি চলে যাচ্ছ। বলে দিতে পারে All right. Yes.
Another judgment, my lord. Previously, my lord, on the Kolkata Municipal Corporation, there is a provision for deemed sanction.
So it says it can be deemed sanction, but it should not contravene or violate any of the.
Why it is, my lord, deemed sanction is inbuilt in it. In the Kolkata Municipal Corporation, there was a provision for deemed sanction that was subsequently taken away. A judgment was rendered in the interact now what will happen. Great Justice Ajoy Nath Rai, my lord, as his lordship was passed an order reported in 1983 Calcutta 39. I will not trouble your lordship, kindly read section 50. Paragraph 10. Paragraph 10.
The page number 49 না 120
122 122 বললাম তো সাইটেশনটা একটু বলুন 922 বললাম তো আমি 83 ওই আগেরটাই তো জানতে চাইছি এটা কত দাম তো 92 সিএলজে 1992 সিএলজে এইচ 122
Based on this proposition, I don't care. Start 12. No, right, my right to construct is there. There should be some reason for not allowing. If I'm not violating any building. No, wait up. Should be 63 is anyway, 12 type of the
দশটা শেষ হোক reach paragraph 12 yes can it
That is inbuilt in 278. However, such permission inbuilt in 278, that sanction is subject to compliance with the rules. 278 is
এটা ছিল এটা ছিল
না তখন এটা
এখানে ওটা উঠে গেছিল
this was subsequent.
উঠে গেছিল এই জাজমেন্টটাতে ভুলটা উঠে গেছিল তাও কোর্ট বলবে যে না তাহলেও ইনস্ট্রাকশনটা থেকে যাবে ইনফরমেশনটা থেকে যাবে রাইট টু কনস্ট্রাক্ট ইজ ইন হ্যান্ড রাইট অফ ওনার শুনে যখন তার রিজন দিতে হবে
ওটা ঝান্ডা বেড়ে দিয়েছে
ওই 77 থেকে দেখিয়ে দেবে আমি বলতে যে তোমাকে আইদার ইয়ে করতে হবে রিজেক্ট করতে হবে
দেখালাম
78 তে দেখিয়ে শো either accord sanction, refuse, accord subject to action. 277 টা follow করতে হবে। 277 দেখে বিষয়টা খুলতে ফেলে রাখতে পারো না বুঝলি তো ডিম sanction ফেলে রাখো হাইকোর্ট has gone to the extent যে যদি নাও থাকে ডিম sanction তাহলেও হবে যদি আমি অ্যাপ্লাই করি রিজেক্টেড হবে
Yes.
now my lord my humble reading of this judgment is that right to construct is a rule
Yes.
refusal is an exception
Yes.
but your lordships can take my lord cue from this judgment if you lordship kindly rule section 277 I have shown to your lordship the deemed sanction but what will happen if you apply under 277 either you have to accord approval rejection or subject to any execution any my lord condition yeah I read for you lords
keep it in abeyance
subject to provisions of section 263 within a period of 60 days after the receipt of any application with building plan or any information or document which the commissioner may require the applicant to furnish that has been done before deciding whether sanction shall be accorded in this regard the commissioner shall by an order in writing either accord sanction a building plan conditionally or unconditionally b refuse on one or more of the ground mentioned in section 280, accord sanction subject to the condition of permission to execute the work. These are the two, my lord, eventualities is within the hand of the commissioner when an application for sanction of the building plan is furnished.
7 দিন একবার দেখিয়ে দাও page 63 না 7 দিন যে হয়েছে
Mr. Basu,
My lord,
if you read 277,
my lord.
if we read that, if within the period referred to in subsection 1 of 277, the commissioner has neither accorded nor refused to accord any sanction
It is
to a
278.
278
Eight, yes.
nor granted any permission to execute a work, the applicant may prefer an appeal to the mayor.
Done that, I've shown to your lordship.
দেখিয়ে দাও 66
Again, my lord, probably my lord has missed.
Let us
I
see.
missed that.
Yes, you missed that.
63
You have
can
not-
come.
Let us see that.
This should be my lord's query.
appeal form নেই
This is no appeal. Appeal means a representation.
Whatever.
But that is there.
63
So kindly come to 63.
দেখিয়ে দাও জুলাই
8 July, they asked for this document.
Page 60.
63.
to submit the plan
So
Submit
there's the
plan.
commissioner.
Yes.
No. This is a different provision which has been.
66
First is you make a
I
application.
application made on the basis of that. This reply has been given.
Yes.
This is the reply.
After the reply and
I'm coming.
everything.
I'm coming. I want to show to the dates. This is 8 July. They asked for certain documents.
No, you show me that you approached the mayor.
yes 66
That's why this is a reply.
the প্রথমে বিল্ডিং প্ল্যান ফার্স্ট কানেকশন ইজ দ্য বিল্ডিং প্ল্যান
No, Mr.
66
Not at all. See, there's a catch there. When we are talking about deemed sanction, it says that if it has not been done in the prescribed period, then you have to approach.
Appeal. Right.
Appeal.
I'm coming, my lord. I've understood, my lord. Kindly read this. On 8 July, what the commissioner was asking for, and I am replying. What? Building plan first. Oh, mic ta kya off.
Oh, that's all right. This is page 63 you're reading.
8 July.
8 July.
Time being, for the time being, kindly consider this is the date of filing of the building plan. Okay,
I'm not, there's no dispute regarding this.
Then,
I'm only asking that once the commissioner has refused to grant,
not,
has not acted on your application,
yes.
neither refused nor accorded sanction, nothing has been done.
Then,
In that scenario, you have to make an appeal to the mayor.
from that. Kindly-
That's what I want to see.
Yes.
Where?
I've shown you probably at that point of time it was not stuck in my mind.
page 66
Page 66, can you see the date? 27
Yes,
September.
yes, this is what I'm
after
asking.
2 after 2 months
And we have said, request for deemed approval.
Even my lord is checking the plan.
This is, you're not pointed it out.
No, my lord, I was hurrying, my lord looking something else. I cannot find fault of the judge. This cannot be.
No, this I didn't see.
This is the method.
Request for deemed
Request for deemed approval of layout plan of the factory. This is all. The nomenclature also indicated.
Yes.
দেখিয়ে দাও
So you had approached the mayor.
Yes, approach it.
And we have said, যদি না করো,
No response from.
we shall proceed
Therefore, we request your layout plan is to be approved by within 30 days for the receipt of this letter. It shall be deemed approval as per applicable regulation and we shall proceed
Yes,
with our planned operation and constructive
Yes.
construction activities according.
yes. Yes.
Comply with that part.
after 2 years টাকা নিয়ে
Who's appearing for the corporation?
appealing for the court
Yes.
First of all, my lord.
Should be right.
Yes.
After this,
their
there
assets
has been sanctioned. I constructed,
their
they
assets
assessed it
and taken money
and revised. And the revised money has been taken on the spot.
next page on the spot এখানে নেই first of all, my lord,
ঠিক আছে, ওটা দরকার।
first of all, my lord, money has not been taken at surprise to them. They knowing fully well they have contravened the law. There is a order passed for the demolition of the entire structure. What happens in the 2015, the area was under the Jamuria municipality. That point of time, there is no existence of the Asansol Municipal Corporation in that area. The Jamuria municipality subsequently 2015 merged with the Asansol Municipal Corporation. They try to say that they are having one old building sanction plan with regard to the initial area, which is much less than the today's area. They started with that. Thereafter 2015, they first give a letter to the corporation annexed here. There is a total contravention of the law. The judgment and the law what my learned
senior friend has submitted before this court is regard to the deemed renewal does not apply in the present case, because it is a case otherwise to establish a post facto sanction of the illegal construction work done by them.
Not really, sir.
My lord, kindly
When-
see.
No, sir, that is not what
They
the
are
record
kindly
speaks.
see their prayer.
The record speaks, sir, that initially they had constructed something when it
But-
was Jamhuriya. Later on, they had asked for a sanction plan.
But they did not, I am coming to that. In
Yes.
2015, they have given a letter. I have show the letters also.
Yes.
The entire argument was made as if it is for a reason for invoking the deemed renewal. Entire argument
It's not deemed renewal. It's
Kindly see
deemed
the-
sanction.
in deemed sanction. Kindly
Deemed
see,
sanction because they had
Yes.
asked for a sanction which
My-
you had not
my lord.
given approval
my
or
lord,
rejected.
Then, my lord, that should be well reflected in the prayer of the prison. Nothing said about that. Kindly see, they are totally challenging the 2023's order and an order of execution dated 2025. So when the order was passed in the 2023 for demolition of the building, I have to go by that order. First, whether they have got ample opportunity, they did not come before this honorable court. They have admitted the position to go against them. Kindly come to the prayer portion.
Yes.
I am coming for the purpose. A writ in the nature of mandamus so and so to recall and cancel design order dated so and so of 11/12/2023 and 1/7/2025. That is our execution. 2023, we found that entire building is constructed without the permission from the Asansol Corporation. They had a old sanction building plan. They failed to convince us during the hearing that what is the area, and kindly first come to the impugn order passed by the corporation. That is at page number 74. Kindly look into that, my lord, for once. What wrong action has been taken, or whether at all wrong. Suo motu proceeding was initiated by the Office of the Asansol Corporation regarding the illegal construction RCC building structural said undertaken by the Man Steel and Power Limited, Jamuria Industrial Estate, Mouja Irka. A field inquiry was made by the technical personnel of Asansol Municipal Corporation. As per the report, Man Steel and Power Limited, Jamuria Industrial Estate, so and so Mouja Irka has erected, constructed building and structural said. The said technical personnel also stated in this report that Man Steel and Power Limited, Chamuria Industrial Estate, Mouja Irka, has illegally constructed and erected the RCC building measuring 32,465.84 square feet and structural shade of 4,38,690. Huge. I asked them to then kindly come to the without obtaining any building sanction from the office of the Asansol Corporation. They have stated that there is no illegality has been whispered by the corporation. Not like order reflects that they have constructed without taking care of the corporation's permission or any sanction building plan. Now, when the entire construction has been done without my permission, they are invoking the clause desperately for deemed sanction. This particular section only applies where they did not make the major construction
Are
work.
you ready to say on affidavit that they had applied for a sanction plan in the year 2019?
No, it is their claim. It is their claim.
So you will
I
deny,
claim-
you will deny that on affidavit. You file your affidavit in
Well, in
opposition.
that case, my
You
lord,
deny that. This is what has become a habit of Asansol Corporation. This is not the first case I am seeing.
Mal.
I am seized of at least 4 matters exactly like this,
in that
where
case-
the sanctions have been given and you're issuing these kind of orders, and these orders are kept in the record for 4, 5 years. For what purpose?
That is
Only your officer will know.
that is unfortunate. If that is so, I know my case. I can take instruction whether they can file an
He is
affidavit.
there in the other matter. He knows what I'm talking about. Mr. Bhattacharya, you know, What was Shonak, right?
Shonak.
Yes.
Only
I called you in that pattern. And all kinds of negotiations. Everything going on.
only thing is that I appreciate, my lord. This type of negotiation is very risky.
So you file an affidavit, state that they are not applied for a sanction plan, and what they are seeking is a deemed sanction is wrong, and it's a post facto approval which they are asking for. File affidavit. We'll see that.
Only, my lord.
I'll send your officer to jail. They have got into this habit.
That is, my lord. My lord.
Yes, sir, we are seeing it in all matters what Asansol is doing.
Definitely, I appreciate your lordship's experience on
It's
this type
absolutely shameful to see what Asansol is doing.
Well, I do
You
not
sit
have-
on the demolition orders for 5 years and negotiate. If you are so prompt, why don't you take action?
That is, my lord. I am asking myself also why they did not.
You ask your officers, don't ask this court.
No, I am asking myself, my lord. Well, only, my lord, I will submit another. I will submit. My lord, there, read petition, if I confine myself. My lord, kindly, I am not having the read petition of the other matters. My lord, kindly see their letter, my lord. They are also equally responsible for the situation. If the Asansol Corporation is guilty, I cannot say that they are also trying to bargain with the corporation. Ultimate objective, your lordships kindly appreciate, your lordship have rightly
What
appreciated.
is your instruction regarding the 20 lakhs which you have taken? What is your instruction? You have taken it in what account?
On the date of demolition.
What have you taken 20 lakhs for, sir?
But they have themselves, my lord. It is their letter. They did not.
Sir, if somebody tomorrow I'll come and give you 50 lakhs, you'll take it.
My lord, my only difficulty, my lord, there was a talk between, definitely there is talk.
What talk?
There have talk between the Asansol and them. They are not also coming with the clean hand. My lord, only kind to appreciate. They have given a
You
letter.
just give me an
Kindly give
answer.
a-
You have taken 20 lakhs for what?
I'm just explaining whatever I
For
can
deemed
say.
sanction?
No, nothing. No, my lord, rightly appreciated. I will not say otherwise misrepresent, but the thing is being misrepresented before this court. This letter was given by them.
Mutual discussions.
Yes, they are taking their innocence. They are taking the plea of innocence that they are not aware of the situation, what is going on there. The corporation, if responsible, equal responsibility for the wrongdoer is also, my lord, my responsibility, my lord. Don't take it otherwise. My lord, they should not give this sort of money in the corporation account, that is by the transaction by RTGS. If it is a check received by the corporation at its office otherwise.
Sir, you are accepting this money? You have taken the money?
If required, we shall refund it. We can refund it. And if required, we shall demolish the structure. If the money is coming in the way.
Demolish the structure only if you can show that they had not asked for a sanction plan and that they have not complied with the relevant provisions, then yes, you can demolish. And that can only happen once you file your affidavit. So we'll pass an order after.
My lord, only thing, my lord, may I submit, my lord, 2-3
Yes, sir.
points, my lord?
You can submit after lunch.
After lunch.
I'm here.
Because, my lord,
I'll
what
hear
is
you,
there
sir.
in the
I'm
application?
in no hurry. I will hear you. All right.
My
You
lord,
also eat well and come
only-
back with
only
all
thing, my
energy.
lord, but my result submission is that if they say that I have applied, they have to show from their own record.
Sir,
They did not
they
speak.
are showing it, sir.
They are showing
They are
it in-
showing letters where they had deposited the building plan and other things. You come and controvert it, we will see that. Then we'll pass an order.
But they did.
Neither I'm believing them nor I'm believing you. We will see only after the
Only thing, my
pleadings
lord,
are
may I suggest one thing in this doubtful situation?
You come back, you make all your submissions.
But only thing that
Come back after
No,
lunch. You are
whether
here
this
in the court after lunch.
I will.
Or you have to leave.
They should not be allowed to take a plea of innocence. That is the well.
Who's innocent?
appreciate.
We
They
will
are not
see.
also innocent.
All right, we'll come back after lunch.
Lord, in the morning matter, that two judgments, Lord, and
Hand over.
Moninuddin Bapari and Lord Supreme Court has approved Moninuddin Bapari. I'm also giving that.
Madam, save it.
Yes. And
I'll
the Supreme
consider.
Court has also approved in 2021 17 SCC that I have given.
I'll consider.
No, always. Always, I'm always.
Something fishy.
I bow down. He said,
Fishy. This thing is something fishy.
always. Don't listen to him.
Don't listen. If I'm not listening, don't listen.
Yes, yes,
My lord,
yes,
my lord, the other, I will humbly request your lordships
yes, sir.
that every case, my lord, depends upon its own merit. Other matter, I am not engaged. The other matters where your lordships have observed the corporation's irregularity. My lord, kindly, my lord, look into their annexures.
My
Why?
observations of the other matter are not going to have any bearing on this case.
No, no, I am just,
It was
my lord.
only for your
Yes,
consumption that I had, expressed whatever
Lord,
I had.
my lord, only your lordship is not convinced as yet because there is the order of demolition was passed in the year 2023.
So let us assume that the order of demolition has been passed in 23.
23.
What were you doing?
Yes, my lord. Then, my lord, I have taken
Negotiating.
instruction on phone with the concerned officials. There was 2-3 meetings. There were
Meeting
other
for what?
for my lord,
Once you have passed a demolition order, you're
Yes.
meeting for what?
my lord,
Yeah,
as because my lord.
Not before hearing, we went there,
No, my lord,
meetings held, thereafter stop.
no. And what happens? Kindly,
But under what provision are they rehearing?
my lord,
that?
I have to.
my lord, let me place my case.
It's on record.
My lord, everything is on record.
This is on
The
record.
letter
Page কত
which I have placed today before your lordship.
Page 75, it is on record.
And first of all, I will start from this. I have already placed before your lordships a letter dated 5th of April 2025, which was received by the corporation on 5th of, it is wrongly stated. The date is, they are depositing money on 5th. Kindly see the letter, my lord. I have given a copy.
Yes.
Kindly, there is a wrong typographical mistake, but it has been having some impact. Kindly, we, Man Steel and Power Limited, would like to formally bring your kind notice on 5th of July 2025. A team of Asansol Municipal Corporation visited our premises to carry out the demolition activity, citing reasons for alleged illegal construction. However, based on the mutual discussion in the interest of the maintaining cooperations with the authorities, we have made a payment of 20 lakhs. They have given this amount on 15th of July. So, kindly see the letter date. It wrongly written. It should be 15th of July, letter dated. 5th July.
That date.
So, wrong date is there. Why I am giving this particular emphasis on this letter? There was a meeting admittedly held between the corporation and the petitioner. For purpose, what I guess, your lordship, for the purpose of retention of the illegal structure, might be.
But they have not made any application for retention.
Then kindly come to when they have given an emphasis on their application, firstly to the commissioner, secondly they are referring it as an appeal before the mayor. They say that after that period they are automatically entitled.
They don't say, the section says.
No, their petition does not say. In the verbal agreement,
No,
Our-
the red petition also says.
petition does not say.
Yes, sir. Please come to.
No, prayer portion, my lord. I am confined to the prayer of the petition. Kindly, my lord, they cannot.
Prayer portion
Prayer,
will
my
not
lord,
contain
prayer portion
their
is very important because
Sir, prayer portion will not contain their arguments.
definitely,
Prayer portion contains the impugn order against which they are aggrieved. But why? There's a background to the impugn order. In that, sir, they are saying that there's a deemed sanction. And that is why they are saying that the order which has been passed is an impugn order, is an illegal order, is in
my lord, I will show
it's a
my lord.
perverse order.
My lord,
It's a perverse order because of the illegalities which are there in the order.
according
But
to your
the-
lordship, my lord,
I am not saying, sir, they are saying.
they are saying. Then let me place the case one in gist.
Yes,
My
sir.
lord, kindly come to the page number 76. Then I
Page
will come to
number?
the page 76 of the petition.
Yes.
as discussed in the meeting held
Yes.
in the chamber of the Honorable Mayor, dated 2024, after the demolition order was passed.
Yes.
Asansol Municipal Corporation on 14th of December 2023, it was decided unanimously that a joint measurement of the existing construction of both the RCC building and factory tin shed would be conducted. I have repeatedly asked them to produce that what is the amount of deviation of the RCC and tin shed structure. Kindly thereafter, kindly, my lord. Kindly come to
Exactly. You know what? You have a cyclo style system of sending notices also. Cyclo style.
maybe my lord. That I
Similar things,
Yes.
similar letter I have seen.
your lordship's robe is better because so far your lordship is
Even the wording has not changed. AutoCAD drawings to be provided.
my lord, your lordship is rightly. It is written in this letter, cyclo style.
This is exactly how you are doing it. And we all know why you are doing it. You have passed a demolition order.
My lord.
You are holding a joint inspection. 2 hearings you have done.
Yes.
What is the outcome of that?
Yes.
First of all, under which provision of law are you giving them a second hearing? Have you recalled your earlier order?
Definitely, my lord. Not yet.
Then, under which provision of law are you giving them again hearing?
And what happens, my
This
lord?
exercise is done under which provision of law?
But my lord, may I just say on this point? On this point,
Why? Because they approached the mayor. The mayor asked you to do all this. And when you get angry and things don't settle, you send again a demolition notice.
rightly appreciated by your lordship. But my lord, as I have already stated, that the petitioner's demand is that to sanction their approved building plan as a under section 278 as a deemed sanction.
Yes.
I'll kindly come to section 277.
Yes, sir. 277 says that you make an application to the commission within such and such period.
My lord.
If the same is not.
My lord, on receipt of the application, the wording I am saying, on receipt of the application, kindly, my lord, we have 2 minutes more with the building plan or any information or documents. My demand from them was all along why the thing was scrapped by passing an order of demolition. I have stated, asked them till date, they have not furnished. What is the amount of the deviation you place your original old sanction plan with the Jamuria Corporation, if any? They could identify it at this type point of hearing. Their representative was
Here
given
it
an
is
opportunity.
Jamuria, Mr. Shonak. Here it is Jamuria. There it was Raniganj. Right? Same. That's right. See the letter which you are writing to them. Same letter. AutoCAD designs to be provided. Cyclo styled, same letters, similar periods.
Machine is my only thing that I can anticipate. The machine and person is same. They do not know that much of language. They are using in this
No, it's not about language. I'm not on the language, sir. I'm about the intent.
Yes.
I'm not on the language of your letter, sir. I'm on the intent of the letter.
Yes, my lord. I'm, my lord, keeping this point. At this point, kindly keep this point set up, sir. I am just placing there one allegation made against us at the time of.
Sorry. You read whatever you have to.
Yes.
Read it.
My lord, subject to the provision of section 263, within a period of 60 days after the receipt of any application with building plan or any information or documents which the commissioner may require the applicant to furnish before deciding whether sanction shall be accorded in this regard. So before taking a decision, it was the precondition to place relevant documents. I have called for at the time of hearing of the demolition matter, when the order of demolition was passed, kindly see, I have taken a plea. What is the order of demolition? This was not ever placed before us.
that how much was the original structure and how much was the new RCC structure of the factory set and the tin structure of the factory set. Kindly look into the order of demolition once again,
Yes.
because 74, my lord, kindly look into once more. Mine specifically was there, second paragraph. A field inquiry report was made by the technical personnel of Asansol Municipal Corporation. As per the report, Man Steel and Power Limited, Jamuria Industrial Estate, Mouja, so has erected, constructed RCC building and structural set. Said technical personnel also stated in his report that Man Steel and Power Limited, Jamuria Industrial Estate, has illegally constructed RCC building measuring so and so, the huge change, and 43 lakhs and so and so of the shed, without obtaining any building sanction plan from the office of the municipal corporation. So, before making any construction of huge change, is a major construction made. Suppose I have passed an order. What was their performance before the order of demolition passed? They, without having any sanction plan, first constructed the whole thing, constructed the whole area,
Yes.
RCC, and thereafter peruse the report of the technical personnel. After conclusion of the hearing, it is evident that so and Man Steel Limited, Jamuria Industrial, has illegally erected, constructed this said RCC building structure measuring so and so, respectively. There are two factories, one Baba Ispat Legal Private Limited and of Man Steel. Hence, Director of Man Steel Power Limited, Jamuria, so and so, is directed to demolish the illegal RCC building measuring so and so and structural shed so and so of the Jamuria Industrial area within 15 days from the date of receipt of this order, failing of which the Asansol Municipal Corporation will demolish the same without further information, intimation, and recover the cost and expenses. So even if I go for the demolition, I will recover a cost and expenses for. So this was the letter. After that, kindly see, this is passed in 11th of December 2023. Then there are letters from the Asansol Corporation to mitigate the grievance. Next page, my lord. Page 75. To mitigate the grievances of made by on behalf of the notice in this matter, the unauthorized construction of the RCC building, erection of unauthorized shed at Jamuria Industrial Estate, so and so, is required to attend. You are required to attend the office of the Asansol Municipal Corporation on 14th of 12. I have given them a time to show that what is their stand, because making a demolition work by fitting a bulldozer or where the economic activity is being carried on.
You consider so much?
No, my duty, one limb of argument was there. In the meantime, whether I am debarred from.
You are so considerate about somebody's commercial interest.
No, my lord. I am.
You are concerned about your commercial interest or their
Yes,
commercial?
I am concerned about my commercial interest.
Your commercial.
Our Asansol Corporation. What Asansol Corporation will get?
Yes.
Part 266 is the provision for demolition.
Yes.
Here a clear power has been given under the statute to the commissioner. Kindly refer to the page number 266.
No, but you are reading page 75, sir. Please tell me, how can you issue a letter like this? Under which provision of law did you issue this letter?
I'm coming.
For what?
I'm coming to that, my lord.
Once you have passed a demolition order, your role is over.
Might be.
After demolition,
it should have been.
Why are you writing this letter? For what negotiation?
It should have been.
What negotiation do you want?
They can say because they were.
No, they can't say. You should say because you are writing, sir.
No, my lord. They are.
For illegal gratifications.
No, my lord. No question. No question of. Otherwise,
then why are you writing this letter, sir?
Then either they have. My lord.
You don't inspire any confidence. Your conduct doesn't inspire any confidence in this court. Your conduct of accepting money, your conduct of writing this letter. What is the purpose? You have passed an order. You should have demolished it. That is for them to do whatever they have to do.
It was, my lord, it was required at that point of time.
What was required?
The demolition, go for the demolition without.
Then why did you write this letter? Why did you accept 20 lakhs?
That amount can be, my lord, refunded, my lord.
The question is not of refund. The question is of intent, your action, sir.
My lord, in this connection, my lord.
You might be aware, ask your, she's
My
assisting
lord,
you.
yes, my lord. I have,
He's assisting you.
yes.
So did you tell him? You might be appearing in this matter, but there are other matters pending before this court. Similar action.
My lord, in this regard, my lord, may I place one judgment of this honorable court?
What will the judgment do?
My lord, no, my lord. What happens in that case? Amount was kept as a retention money, or it is?
The question is not of retention.
No. My lord, what has been the observation of the court in that case? My lord, kindly hear me. Money was taken by the corporation. They deposited the money. Then the retribution was preferred. When the retribution,
Money would have been deposited if the corporation would have asked for it. Give me a letter that you have demanded X amount of money for retention.
my lord,
Where is your demand? Where have you demanded that you pay X amount of money towards retention fee? Then they would have deposited. Today you are unable to even explain under which head you have taken the money.
my lord, only my lord, my submission is that only my submission is that. The other matter, the similar thing happens. Corporation to get money in their own account, official account. Money was accounted for on the official account that illegal construction was done. After the order of demolition, a retribution was preferred. Similar circumstances. In that retribution, the writ court, this learned single judge, gave a protection that if this amount be deposited, no demolition at this moment. Then thereafter they went for appeal. In the appeal court said that when the learned single bench is holding over the matter, then I am not confining myself as to the merit of the case, and the said retribution is against the Asansol Corporation. I can, my lord, place the two things. That order I can place, and second, because this is not the first time as your lordship appreciated, the corporation has done so. The other, there is board resolution. The board resolution. Order দাও. Order দাও একটা. But his division bench's order was there. Copy the
Division bench relegated the matter back to the single judge.
Copy. But that matter is pending against the corporation.
Where is the interim order?
My lord, kindly see, the issue was dealt with.
Sir, second paragraph, read. It appears that sanction of a building plan was obtained. Here your entire case is there's no sanction.
Here, my lord.
This is deviation or additional construction. This is not unauthorized construction, complete unauthorized construction.
My only submission on this aspect is that here, my lord, this same municipal corporation, Asansol Corporation, giving the sanction plan. In this case, according to their petition, they have stated that old building.
Entire case is different, sir. Here you are asking.
Jamuria.
See, sir, there is already a sanction building plan here in this matter. They had constructed an additional area. Additional area was 20 times more than the sanction plan.
My lord.
So you had raised a demand of X amount of money, stating that this can be compounded or whatever word you can use. Regularized compounding. Compounding can be done.
Better word, compound.
We use the word compounding in
he always tries
municipal laws. And
if there is a penalty, that can be compounded. There is a provision under the statute to regularize.
No, but they have asked it. There is a demand.
They ask it for regularization.
So the issue is just different, Mr. Bas.
এটা অন্য জিনিস এখন রুলসে অনেক কিছু আছে সেটা কোনোদিন কমপ্লাই হবে
আচ্ছা ঠিক আছে my lord thing is that only difference I can identify from this case and that matter. My case is that
entirely different, sir. Your facts and this facts are entirely different.
Kindly consider here, my lord, initial building plan was obtained from the Asansol Corporation. In this, my case, building plan was initially obtained from the Jamuria municipality, according to them also. They did not produce the deviation. Then they made a mass construction of the RCC structure, tin set, and the corporation asked them, as I have cited the page number 74 or 70.
just before shown, page number 76. Then এরকম করলে তাহলে আসবো না দাদা, এরকম করলে আসবো না। This is the only deviation that they obtained initial building sanction plan from the Jamuria municipality. But the entire illegal construction is before the Asansol Municipal Corporation. Only difference is that.
Not only different, sir.
And there is no other difference. Here also, my lord, money was deposited.
Not applicable.
And after this thing, my lord, he has cited several judgments for deemed acceptance. First condition they have to satisfy for deemed acceptance of the sanction plan as per 278 to give the proper particulars. Otherwise, the corporation never will come to in a position to decide the matter. Here, my lord, no document has been shown that how they have satisfied the corporation, what was the actual deviation. Kindly look into their application in page.
There's no deviation. They're asking for sanction plan.
No, my lord, they have in the meantime kindly considered that after the initial plan obtained from the Jamuria municipality, they have made a mass change in the nature character of the property. They have made such a change that because in the meantime, from 2005 to 2010, they have purchased one after another plot, kindly, for their sponge iron factory. Thereafter, they have obtained permission from the Asansol Development Authority. Thereafter, they have applied according to them. Kindly come to the page number 63. Kindly come to page number 63, R, Annexure R.
Yes.
They are just saying, as desired in your letter so and so, please find enclosed the following documents. Building plan. Building plan means the original plan with Jamuria municipality. Is at all available.
Yes.
Here, this building plan needs to be compared. They could not say anything in their application. If that be considered as the first application before the commissioner, then kindly see, have they stated anything that I have satisfied you so far the illegal construction or the portion which I have constructed without the authority of law without obtaining the sanction plan of the Asansol Corporation? Have they said so? Then the case would have been a misconsideration by or wrong consideration by the Asansol Corporation. Nothing, just forwarding some letters and documents. Thereafter, next letter, page number 65. As per above, it is our request to please approve layout plan for our integrated. Layout plan means the entire site plan. Layout plan does not say that the building plan. There is a difference between the building plan and the layout plan. Before making any construction, they ought to have obtained the required sanction from the Asansol Corporation. That is missing in their own record. They have not written so. They have not written nothing about that. Thereafter, kindly see their next letter, which they are now harping, page number 66. Honorable Mayor, kindly see as per above, it is requested to please approve a layout plan for your integrated. Again and again, they are saying for the layout plan. The layout plan is tantamount to the building plan for the construction of the additional area. Then question would have come for consideration for deemed acceptance of the sanction plan. Deemed acceptance provision says that you have to support adequate documents, information to the corporation to come to a conclusion that what actually you are trying to do. What is the amount of construction you propose to make? Nothing. Totally, it is spelled nothing about that. Kindly see. Now, my lord, in connection with this particular letter, kindly I refer to section 279 of the Act.
Yes.
My lord, what I try to say, that no post facto sanction can be given. The order passed on on December 2023. Now, page number section 279 says that notice to the commissioner before commencement of the work. Not less than 7 days before the erection or re-erection of a building commences, the owner of the building shall send to the commissioner a notice in writing specifying therein the date on which such erection or re-erection of the building is proposed. Can they show, my lord, from their documents that yes, I'm not justifying the amount, acceptance of the amount, but they have to, before making any construction, their duty is to comply with section 279. This is not apparent from the record. Not it apparent from the record that they are trying to obtain the sanction building plan. Thereafter, my lord, kindly see 266. 2. Even if there is an illegal construction without the sanction plan, the power is given, subsection 2 of section 266, that the commissioner may make an order under subsection 1, notwithstanding the fact that the assessment of the building has been made for the levy of the property tax on lands and building. My lord, this is to justify that property tax can be charged. Property tax can be charged on the holding. Even there is no sanction building plan, if it is found that there is an illegal construction is made. Kindly come to another provision. My lord, 277 is the first condition. They have to comply. They have to speak for the specific prayer that they are obtaining they are making the prayer for the deemed renewal with the documents. Documents was completely silent. Even in this particular writ petition, they did not annex copy of the earlier Jamuria municipality sanction plan.
They have.
Huh?
They have given the building permit of.
I do not get it, my lord, in my copy. Plan is not given, my lord.
Plan is not given.
Plan is not given.
Approval is given.
So, unless the plan is given, how can I measure by inquiry the extra portion?
Not on that, sir.
Yes, my lord. Let me, my lord, place the case, my lord, in otherwise, my lord. May not be, my lord, helpful for the other cases. But in this case, they have to say, my lord, deemed renewal, if it is accepted as a statutory law, if it is accepted as a right automatically given to the writ petitioner, then so many persons will come to this court, and similarly they will say that the corporation is tied over the issue, because in the meantime, corporation done two things. The board resolution has been taken by the corporation to handle the similar type of cases where the demolition order was passed as per the board resolution. My lord, kindly see this board resolution. And held on 19th of, kindly see this copy. Everything was আমি পড়ে যাই, তুমি শোনো না, পড়ে যাই, কাগজ দেবে না দিদি। Kindly come to the last but one page, page number 4, last but one page.
Yes.
The additional charges for RCC construction done in excess area beyond the sanctioned area in respect of the sanctioned building plan is RCC for structure is for legality is otherwise. Board resolution was made. I have, my lord.
So you are arguing against yourself. If this is what you are arguing, that is in existence, then you raise a demand. Then why have you passed a demolition order? If you have a provision where you can regularize the additional areas by accepting charges, then what is the need and purpose of issuing a demolition order? Why have you issued the demolition order? You withdraw it. You issue a demand.
In that case, my lord, if your lordship kindly pass that direction.
Why should I pass that
My lord,
direction?
because
I'm
they
not
have,
running
my lord,
the
they have, my lord,
corporation.
specifically, my lord, assailed the order of the
You
demolition.
file an affidavit, say that you're withdrawing the demolition order, and you will pursue additional charges, regularization based on charge.
My lord, let the direction be passed
Why should I pass the direction, sir?
for affidavit,
Yes.
filing affidavit.
Yes.
I will file. And otherwise, my lord, they will take the steps in accordance with law.
File your affidavit. Take down. The petitioners, the petitioner has preferred the petition. The petitioners have preferred the present writ petition challenging the demolition order dated 11/12/2023 and 1/7/2025 issued by the respondent municipality in respect of petitioner's premises situated at Jamuria Industrial Estate, Mausa. What is this, Mausa? Ikra. Mausa Ikra. P.O. Nandi, Jamuria. Full stop. By virtue of the said orders, the respondent municipality has sought to demolish an alleged unauthorized RCC building measuring 32,465.84 square feet and a structural shed measuring 4.38.492.32. 4 comma kar do 38,692.32 square feet, both situated on the said premises. Learned senior counsel for the petitioner submits that the petitioner had legally purchased approximately 25 acres, 24.27 acres of land with prior permission from the then Jamuria municipality, for purposes of establishing a sponge iron unit. Full stop. Subsequently, permission was granted for expansion of the unit into an integrated steel plant. Full stop. Learned senior counsel further submits that in June of 2019, in May/June of 2019, the petitioner submitted an application for approval of the building plan pertaining to the expansion project. Full stop. All requisite documents, as demanded by the respondent corporation, were duly furnished, and a sum of rupees 23,09,208 was deposited towards building plan sanction fees. Full stop. Senior counsel further submits that despite full compliance with all the procedural requirements.
3 lakhs is not for this one, the previous one.
For Jamuria?
For Jamuria.
All right. वो काट दो फिर उसको.
No.
Respondent were duly furnished.
Jamuria.
Were duly furnished. Documents were duly furnished. Documents were duly furnished कर दो. Were duly furnished. Were duly furnished. बस क्या काट दो. Despite learned counsel for the senior counsel further submit that despite full compliance with all the procedural requirements, the respondent corporation failed to issue the sanction plan. Full stop. The petitioner addressed a letter dated 25/7/2019 to the chairman, Asansol Municipal Corporation, requesting
Mayor.
First to the corporation, no? First to the,
Rightly recorded, first to the borough chairman.
first to the chair,
Yes, yes,
first to the chairman,
chairman. Thereafter,
then to the mayor.
yes, yes, then to the mayor.
First is, sir, first is, letter is 25th July. Please see the letter.
25th
This is on, yes, this is page S.
Yes. So far as the appeal is concerned, the
Yes,
statute,
yes.
that is to the mayor.
Yes. Yeah. Page 65, the chairman AMC requesting expeditious disposal of the building plan application, full stop. No response was received, full stop. Thereafter, the petitioner preferred a statutory appeal before the mayor in council on 27/9/2019, which also remain undecided, full stop. It is the contention of the petitioner that in terms of section 278, in terms of section 278 of the West Bengal Municipal Corporation Act 2006, if no final decision is communicated within a period of 60 days, right? Within a period of 60 days from the date of submission of the application, the same shall be, the building plan shall be deemed to have been sanctioned.
Only one thing, my lord. The amount which my learned senior friend has stated, 23 lakhs and odd.
That is for Jamhuriya.
That is for, my lord, they have stated that they have deposited it before the Jamhuriya municipality.
That's what he said.
Not yet, my lord.
That's what he said. That's what he said.
They have said.
Oh, sir, they have said that.
Yes.
It's for Jamhuriya only.
Only, but
yes,
but
not here.
Not, my lord, who is put in the record, whether it is for the Jamhuriya or any other statutory bodies. They cannot, my lord.
Sir, it's okay. They are making a statement.
My lord,
that is their statement.
My lord, my lord. I am denying that. Simply, sir.
Relying on this provision, the petitioner proceeded with construction and operationalized the integrated steel plant, which presently provides employment to approximately, how many people are there?
How many people are working there? Just a minute, give me the fact figures.
1,600. 1,600 persons, and which has an investment of about rupees 1,600. It's there, of approximately 1,600 crores has been made, full stop. The petitioner also asserts that they have been regularly paying the property tax in respect of the said premises, full stop. Learned counsel for the petitioner further submits that the respondent corporation suo motu, corporation, suo motu, initiated proceedings against the petitioner's premises, and after conducting you were given an opportunity of hearing.
Yes.
They called us.
And
No, they were present.
and after conducting an inspection and affording an opportunity of hearing, passed the impugned demolition order dated 11/12/2023, without considering the petitioner's claim that the construction stands protected under the doctrine of deemed sanction, full stop. Despite several meetings between the parties, the respondent again issued a second demolition order dated 1/7/2025, proposing demolition on 5/7/2025, full stop. On the said date, the respondent allegedly visited the site and made an on-spot demand of rupees 20 lakhs comma, perpetually towards a fee, towards regulation fee of the deemed sanction, full stop. The said amount was paid by the petitioner, full stop. Despite the said amount being paid, the respondent corporation again approached the petitioner's premises for carrying out the demolition action. Full stop. Learned counsel for the respondent corporation submits that the construction has been carried out without any sanction plan. Full stop. He further submits that no deemed sanction can be accorded to the petitioner since the petitioner has not fulfilled the requisite condition for sanctioning of a building plan. Full stop. Counsel for the respondent corporation further submits that the 20 lakhs which was taken by the corporation can be refunded back to the petitioner. Full stop. What else?
My lord, no notice has been given under section 279 before making
He-
construction.
He further relies on section 279 of the West Bengal Municipal Corporation Act 2006 to support the contention that the petition that even assuming that there has been a deemed sanction, the petitioner could not have carried on with any construction without providing a notice to the commissioner under section 279 of the said act. Full stop. What else?
266(2), subsection 260, subsection 2 states that even notwithstanding the issue of any demolition, the corporation can collect the property tax
We are not on property tax. We are on demolition.
because they are said so.
No,
that
we
we
are
have
not.
paid the property
No,
tax.
we are not getting into property tax right now.
And
In
only
this
thing is
petition,
that-
we are only concerned with the demolition.
And
Anything else?
one of the other matters is pending on the same issue. I have stated before another single bench. The matter is pending.
Learned counsel for the petitioner has relied on a judgment MAT 1996 of 2023 to support his contention. Full stop. The facts of the above matter is completely different since there was a building plan which was in existence in the said matter, and that in contravention of the said building plan, the alleged there was an excess construction, and in view of the same, the corporation had raised a demand of 20 crores on the appellant as a precondition for regularization or permitting the unauthorized construction. Full stop. The facts of the MAT so and so is not applicable in the present writ petition since there is no sanction plan issued by the corporation, and that since no sanction plan has been issued, there is no question of any deviation or excess construction. Thus, the dicta of the above MAT so and so is not applicable in the present writ petition. Full stop. Learned counsel, anything else?
Well, I have said so that in case of withdrawal of the demolition order, in case that we
It
shall,
is interesting to note that despite passing of the demolition order,
in case, my lord. We have to make raise demand. My lord, my lord, may I just submit one thing?
just a minute.
Suppose, my lord,
It is, wait a minute. it is interesting to note that despite of the passing of the demolition order dated 11/12/2023, the respondent Asansol Municipal Corporation issued a letter dated 12/12/2023, wherein they had proposed to mitigate the grievance of the petitioner by giving him a hearing. Full stop. Though nowhere on record it is stated that the earlier demolition order has been withdrawn by the Asansol Municipal Corporation. To issue such a communication, which is not supported by any provision under the statute as to what was the purpose of conducting hearings when the corporation had already passed a demolition order and the same had not been withdrawn at the time of issuance of these letters. Yes, what else?
My lord, only thing which is absent in this petition, that they have not placed the original sanction plan. This is not placed in the petition.
They have
Not placed. How can I quantify the
learned counsel for the
demand
petitioner.
unless the
Petitioner states that no sanction, learned counsel respondent corporation states that no sanction plan has been placed. It is contrary to the impugned demolition order dated so and so passed by the corporation, since the entire issue is non-grant of sanction and the impugned orders have only been passed since there has been no sanction plan. So to say that the petitioner has not placed a sanction plan is contrary to the records. What else?
affidavit may be filed by the corporation in the
Learned counsel for
final dismissal of
the
this
respondent corporation seeks and is granted 4 weeks time
yes,
to file affidavit in opposition, reply to the same if any within 2 weeks thereafter, full stop.
within 4 weeks, my lord. 4 weeks, my lord, because
I've given you 4 weeks, sir. Either I speak slowly or I speak
no,
less.
it is my misunderstanding.
It is the takedown. It is the specific case of the petitioner that the respondent corporation has failed to either sanction or reject the building plan within the statutory period of 60 days, 60 days. And hence, by operation of law under section 278 of the West Bengal Municipal Corporation Act 2006, the said plan stands, the said plan stood to be sanctioned, full stop. This issue can only be adjudicated after examining the stand taken by the respondent in its affidavit in opposition, full stop. In view thereof, in the meanwhile, the operation of the impugned order dated so and so shall remain stayed for a period of 12 weeks or until further order, whichever is it.
Grateful.
12 weeks.
Grateful.
Should I take back the judgment, sir? Find it. It was not recorded, not necessary.
You want?
No.
One-sided.
I can record those.
Unnecessary, I don't want to give trouble to the court.
There's nothing. Just keep one MAT, keep it.
12 weeks.
I'll keep it. This
Yes.
might be useful for me. Let me go through it.
Grateful, Lord.
Returnable on.
Written.
4 weeks to 6 weeks, 8 weeks. After 8 weeks, kya hai? So we'll have it after vacation.
My lord.
Yes. Before vacation, not me.
4th of November.
4th of November. তাহলে 16 weeks করতে 12 weeks কেটে যাবে কি
কেটে যাবে
Oh,
12 weeks
it requires more time.
12 weeks कब खत्म हो रहा है
16 weeks.
16 weeks
No, no, my lord.
हाँ।
Let it be, let it be.
তার মধ্যে তো আমরা হিয়ারিং হলে অর্ডার कर दो फिर is granted till for 6 if we can have it on 4th November or 3rd November 4th November
November.
interim order is granted till 15th of November 15th of November 15th of
Grateful.
Third.
Grateful.
Grateful, Your
Oh,
But mayor in council.
mayor in council. That should be mayor.
27 July, mayor.
That appeal.
That appeal.
এটা কি হচ্ছে এদিকে কি দরকার পয়সা
I am for the petitioner, my lord. This is an assigned matter to your lordship, education matter. My lord, this was taken up by your
I
lordship.
appear for the respondent in this matter.
My lord, by filing this, my lord, I have sought for, my lord, implementation of a direction passed by the Honorable Division Bench of this Honorable Court, which was affirmed by the Honorable Supreme Court, my lord. My lord, the fact is this, that we are, my lord, contractual part-time teacher. We earlier, my lord, filed a writ petition, my lord, seeking equal pay for equal work. Now, there are several writ petitions. One writ petition was taken up by a coordinate bench of this Honorable Court, and, my lord, that writ petition was allowed. Now, state preferred an appeal. My lord, the appeal bench, my lord, passed two directions. The first direction was the Honorable Division Bench, my lord. I'm sorry. The Honorable Division Bench, my lord, modified the order passed by the learned single bench to the extent that, my lord, the Division Bench directed the state to release salary from 2010 to 2013 and then directed the Principal Secretary Education Department, my lord, to consider his representation. Now, challenging this, my lord, the state preferred an SLP. My lord, at that point of time, my lord, we filed an application before the Honorable Apex Court, my lord, so that our writ petition may be tagged with that SLP. Now, all those matters, my lord, the transfer application as well as the original SLP was taken up by the Honorable Supreme Court, and the Supreme Court, my lord, was pleased to, my lord, affirm the order passed by the Honorable Division Bench and directed the state to, my lord, consider the directions passed by the Honorable Division Bench. Now, same order was passed in respect of, my lord, this petitioner also. Accordingly, my lord, the state, my lord, released the first portion of this order, my lord, that releasing this amount. That was, my lord, we have received this. I have stated, my lord, in my petition. But so far, my lord, the consideration of our representation is concerned, my lord, that second part has not been done. That has not been complied with. Your lordship was pleased to direct my learned senior friend, my lord, to take instruction whether this was that opportunity of hearing was given to or given or not. My lord, the Honorable Division Bench order relevant is at page 52. It starts from page 20. Relevant paragraph is at page 52, my lord. My lord, the second paragraph, my lord, may I be permitted to place this?
under such circumstances
Yes,
we
under
modify.
such circumstances, we modify the order of the learned single judge by directing the appellant, that is the state, to make payment of salaries equal to basic pay in the scale of pay of a regular teacher working in higher secondary section in a non-government aided higher secondary school with effect from 28 July 2010 being the date of the order which is quoted above till 24th December 2013 when the previous GO dated such and such stood withdrawn under GO dated 24 December 2013. The state government order restrain any further appointment. This is not relevant. The last two words, my lord. In the event, the writ petitioner made a representation before the Secretary School Education Department in justification of basic pay for the period from April 2007 till December 2009 and after 24 December 2013, demonstrating discharge of similar duties within a period of 4 weeks after the lockdown is relaxed and the normal functioning of the schools and colleges are restored, the Secretary shall consider such representation within a period of 3 weeks thereafter upon giving an opportunity of hearing to the writ petitioner as well as the concerned school. Now, my lord, challenging this, my lord, the state, my lord, preferred an SLP. The order is at page 57, my lord. My lord, your lordship will find, my lord, in the middle,
the transfer petitions 1288 to 1297 of 2020, my lord, those were tagged, my lord. Then kindly consider, my lord, the second paragraph of this order having regard to the fact that the impugned judgment was passed on 3rd September 2020 and the same has remained stayed in terms of the order passed by this court on 20th September 2021 in SLP number such and such. It is deemed appropriate to direct the state government of West Bengal to make compliance of the impugned judgment within a period of 3 months from today. The relief granted in the said judgment shall also be extended to all similarly placed private respondents, including the interveners, impleters who have moved applications in the present petitions. Then the transfer petitions. In terms of the order passed in petitions for special leave to appeal, civil number such and such, the transfer petitions are disposed of along with pending application, if any. Now, my lord, I have stated, my lord, in paragraph 15, my lord, at page 12. Paragraph 15, my lord, I have stated that petitioner state that in terms of the judgment and order dated 16 July 2024, the respondents released the following arrear salary for the period from 28 July 2010 to 24 December 2013, which was transferred to their respective bank accounts. My lord, the next page, your lordship will find the amount and the date of transfer I have indicated. Now, pursuant, I'm sorry.
Yes.
Now, this amount has been, my lord, we received this, but pursuant to, my lord, the Honorable Division Bench direction, my lord, we also made a representation which is at page 61. This is pending, my lord. Within 3 months, my lord, the Honorable Division Bench directed the state, my lord, to consider this issue. So far, the balance amount is concerned, my lord. Page 61 representation we made pursuant to the direction of the Honorable Apex Court's direction order.
Yes, sir.
My lord, your lordship has seen, lordship kindly have a look to just pursuant lordship's time. Lordship kindly have a look to the prayers made in the writ petition. Page 16 onwards. Page 16 at the bottom. Mandamus commanding the respondents and their main agents and assigns to forthwith and or immediately implement the order dated 16th of July 2024 passed by the Honorable Apex Court in connection with such and such, and immediately considering the petitioner's representatives 11th of August 2024 and to act in accordance with law by acting in the manner as aforesaid. Now, my lord, this, my lord, this paragraph 15, page 12 is the answer. My lord, they have got the benefits pursuant to order of the Honorable Apex Court, my lord, the marged with the order of the division bench and the Honorable Single Judge. So they have got the benefits. Now nothing remains. They want hearing. Hearing for what purpose?
There's a direction for a representation.
No, my lord, that has been considered. My lord,
where is it considered?
The original petitioners. And here, my lord,
the benefit will be extended to everyone. That's what the.
My lord, I'm sorry, my lord, for the interruption, my lord. Lordship, my lord, kindly visualize the situation. The consideration of the representative will not make any difference ultimately, because they have got the benefits.
I'm only concerned about the fact that there's a direction passed by the Honorable Supreme Court, whereby you have been directed to consider the representation, and that has followed from the division bench order. So that has to be complied with. Have you complied? If you have complied,
if I may, my lord, hand up one order, recent order, 15th of January. Yes, sir. Kindly have a look. I think my learned friend has got it. Because kindly have a look, my lord. This is the recent order. This is not part of the writ petition. The writ petition was filed after this 15th of January letter or recent order of the authority. Lordship kindly sees the recent order in compliance with solemn order of the Honorable Division Bench of High Court at Calcutta dated 3rd of September 2020. The recent order, Honorable Division Bench order was internally pleased to direct that understand to modify the order such and such. Then the order of the Division Bench is quoted. And then Lordship will, in the next page, Lordship will find the state favored SLB being number so and so. Then the operative part of the Apex Court order is quoted here. Then, in compliance with the aforesaid directions of the Honorable Courts,
Hearing was fixed on 3rd of October 2024 after due notice to the petitioners and all concerned. The school authorities and others attended the hearing before the undersigned. The petitioners are claiming for disbursement of equal pay as that of regular assistant teacher of government wages at schools and compliance of directions with the Honorable Court, and they sought accommodation to place relevant documents in respect of their claim. Accordingly, an interim order was passed with a memo number so dated 4th October 2024, allowing time to place written submission from all the sides in respect of claim, and leave was also given to provide details of interveners in pleaders in terms of order of the Honorable Supreme Court. The hearing resumed on 19th of November 2024 after due notice to all concerned. In the hearing date 19th November 24, the petitioner Borun Ghosh and one authorized representative of the petitioner Anirban Ghosh, learned advocate of the petitioners, headmistress of petitioners schools, district schools AC Purva Bardwan and additional district schools Paschim Bardwan, secretary law, additional secretary so and so, senior law officer, and so and so forth of the above present. Then the following facts are revealed from the averments made in the instant petition, submissions made by the advocates of petitioners, and report of the district schools AC Purva Paschim Bardwan and school authorities. Then, my lord, this lordship kindly have a seat. The government of West Bengal School Education Department, by a notification number so and so, created 900 posts of part-time teachers for higher secondary section of different recognized aided sponsored higher secondary schools in West Bengal on a fixed pay of rupees 2,000 per month on contract basis as part-time teachers to be filled up by the managing committee or ad hoc committee or administrator, as the case may be, of the higher secondary schools. Then, in order to appoint such part-time contractual teachers, the Director of School Education issued a guideline for recruitment, and accordingly the school authority conducted the interview following the procedure stated in the said guideline. Guidelines made it clear that before issuing the appointment letter, the contract paper in the proforma prescribed by the Director of School Education, now Commissioner of School Education, would have to be signed by the candidate and the school authority. Petitioners herein were appointed as part-time teachers on purely temporary and contractual basis for higher secondary sections for the higher secondary schools. Petitioners Anirban Ghosh accepted the contractual engagement of part-time teacher in 2003 for teaching economics in higher secondary section in Khandra High School, Bardhaman, and the petitioner Borun Ghosh accepted the contractual engagement of part-time teacher in 2003 for teaching geography in higher secondary section in Bitra High School, so and so, Purva Bardhaman. Their letters of appointment have been issued by the Secretary Managing Committee, so and so. Well, this is the long order. I just take your lordship to the long order. I just skip. Lordship, kindly have a look to the operative part. It starts from page 11, paragraph 9. Lordship, got it, Malad? Paragraph 9, page 11. Having considered the facts and circumstances of the case, relevant records, submissions of parties, and the law applicable thereto, it may be observed that the quality of work varies and depends upon the qualification, workload, experience, etc., that a professional handle during his serving years. There are numbers of instances of doctors, advocates, or professionals from other fields, including education, who charge higher than that of others in the same field. Their higher fees pay remuneration depends on the quality of works and the reputation they earn by rendering such qualitative works over the years. The quality of work of a contractual teacher who was engaged by a school committee for some limited number of classes only in higher secondary section cannot be equated with the volume of quality of work rendered by the regular teachers who have entered into public service through open, strict, state-wide selection test. Then, part-time teachers engaged in different higher secondary schools in higher secondary section are in a different footing than that of the regular teachers of government-aided sponsored schools. No one who is in different footing can claim equality under the Constitution of India. Right to equality emphasizes the principles of equality among the equals. Principles of equal pay for equal work cannot apply unless there is a complete and wholesome identity between the two groups. Then the reasoning part is there. Then I just omit the other part. I just take
you have given a hearing, sir.
The ultimate part.
Your Lordship, this order that my learned senior friend has placed, kindly consider, my Lord, the first 3 lines of this reasoned order. This is a reasoned order, my Lord, passed in respect of Anirban Ghosh and Borun Kumar Ghosh, my lord, who preferred that special leave petition. Your lordship kindly consider page 53 of the Honorable Division Bench direction. The Honorable Division Bench directed the Secretary to consider the representation upon giving an opportunity of hearing to the writ petitioners as well as the concerned school. We are, my lord, we belong to a separate school. We are discharging our duties in respect of different schools. Now, we have not received any notice. Our school has not received any notice. The Division Bench said that the Secretary will consider the documents produced by the school.
Nothing better can happen. If you want to challenge these kind of orders, you challenge it. You want them to
But
file an
our
affidavit.
records have not been placed before the Secretary. This is, my lord, I tell
They
you,
can't improve anything beyond this. This is in
It is, my lord,
compliance. This is
I
in
cannot
compliance of the
challenge-
order.
my lord, may I say this? I cannot subject your lordship's kind corrections, my lord.
Let them file an affidavit. Be happy about it. Nothing will happen.
But I have to accept this, my lord, without knowing this fact that our school was not received any notice. We have not received any notice. Let the state say that we have received any notice, any kind of hearing notice, my lord.
State is not going to travel beyond this. Anyway, you file your affidavit.
My lord, affidavit, my lord, otherwise it will be, my lord.
That's what can I,
They have
what can
got
be
the
done?
benefits, my lord.
They say,
Hearing will result.
very well.
They
my lord,
will-
Let them file their affidavit. They'll bring everything on record, whatever they have to say.
Very well, my lord.
The petitioner has preferred the present, preferred the present writ petition seeking implementation of order dated 3/9/2020 passed by the Honorable Division Bench in MET number 1221 of 2019 and MET 1367 of 2019, which was subsequently upheld by the Honorable Supreme Court in SLP number 2809 of 2021 and TP bracket C number 1288 of 1288 to 1297 of 2022. Full stop. Learned counsel for the petitioner submits that the Honorable Division Bench and Honorable Division Bench by order dated 3/9/2020 had modified the order of the learned single judge and issued the following direction. 52, 52, yeah, 50. ठीक है 52 से यहाँ से उठा के यहाँ तक 54. Yes. Full stop. The respondent unsuccessfully challenged the aforesaid order before the Honorable Supreme Court. Full stop. Learned counsel for the petitioner further submits that although the respondent has partially complied with the order of the Honorable Division Bench by releasing the arrears of pay for the period 28/7/2010 to 24/12/2013, it has failed to consider petitioner's representation regarding the grant of basic pay for the period 2007 to December 2009. That's your contention?
yes, my contention is, my lord, the Division Bench said each and every case has to be, my lord, considered in terms of the records to be produced by the school.
And for the subsequent period to 24/12/2013, during which the petitioner states to have continued discharging their duties. Full stop. Petitioner further states that the respondent have failed to discharge. The respondent failed to abide by the direction passed by the Honorable Division Bench, wherein the petitioner has not been given an opportunity of hearing of his representation. Full stop. Learned counsel for the respondent states that a reasoned order has been passed on 15/1/2025 after in compliance of the Honorable Division Bench order dated 3/9/2020 in MET number 1221 of 2019 and MET 1367 of 2019 as well as in terms of the direction passed by the Honorable Supreme Court. Full stop. Learned counsel for the respondent state seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks. List after
Lordship gives at least 4 weeks time.
4 weeks.
4
That's what I've given.
I'm sorry, I couldn't hear.
10 weeks.
Only thing, my Lordship, kindly consider the penultimate paragraph of the order I've handed up.
I'm not saying anything. I have only recorded that you have passed an order. You file an affidavit, we'll deal with it.
Very well.
Today there's no point.
Already.
Today there's no point in recording it. You file an affidavit, we'll dispose it.
Very well. No, I just wanted to say, my lord, that in the penultimate paragraph, rejection was made. Even then, the direction is, however, they have been given the benefits and they have got the benefits administratively.
Yes.
So, my lord, nothing remains in the writ petition.
Stated that I have received the amount. But the second point is concerned, my lord, we have
They
not
are only
received
talking
any-
about the representation.
Yes.
Carrying of the representation.
For
It will
payment-
not make any difference
No,
ultimately.
no, this is payment beyond 2013.
We- We will see that. After 10 weeks. 12 weeks कर दो. Of November, give it, मैं बता रहा हूँ. Give it on 12th of November.
I'm grateful.
It's an assigned matter to your lordship.
Yes.
An assigned matter.
Grateful.
For the petition read by Mr. Raghunath Chakraborty. Lordship, praying for 2 weeks time to file exception of their report, Lordship, because on the last week we have received the report.
Where is your report? So Das report.
My lord, I am appealing on behalf of the Kolkata Municipal Corporation.
Where's the report?
My lord, here is APDP is here.
Give it. Affidavit, report in the form of affidavit is filed on behalf of the corporation. Full stop. The same is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted
2 weeks.
2 weeks time to file her exception to the same. List on after. In both you're filing your
In both.
Same-
11 and 12.
Respectively, two cases are.
same report in both.
No, same, not same report, but two types, two different nature of the work.
All right, where's the other report?
The two have been just now.
Acha, okay. Oh, sorry, sir. So this is in two, क्या है ये?
Separate case में.
25616.
দেবে মানে
Order frame कर दो. No, अलग.
তোমাদের দুটো কপি দিই
List after 8 weeks कर दो. कब होगा 8 weeks? All right. Within vacation. So list it on 11th November. 11th November.
Grateful, Lordship.
কবে কবে আসবে?
I'm for the petition.
State respondent in this matter, as per my lord direction, I am filing the.
Pursuant an order, my lord, dated, my lord, 7/10/24, my lord, my preliminary complaint is that the municipality has constructed several shops on encroaching upon the land of the, my lord, the national highway. Now the state has filed a report because state is the custodian of that highway. So lordship straight away come to.
You want to file exception or you want to
No,
argue?
because the state has accepted my case. Please see page 13. The state, page 13. That is the sketch map prepared by the state.
Yes.
Not kindly sees the in the sketch map at the bottom. The national highway runs in north-south direction. The highway occupies a width of 68 foot. Adjacent to this private property lies within the same mosa immediately after the west of the highway boundary. Out of the said wide stretch, an area of such and such has been constructed upon by several vacant stalls. This Pakka construction is situated directly in front of Gopal Maiti's building, which is my building. That they have accepted that the shops have been constructed on the national highway, and the construction is at the instance of the Contai municipality. And this is my case. This requires to be demolished, because if your lordship sees the sketch map also, they have given the stretch of the road, and this construction is at the left hand side, slightly in diagonal in nature. And if your lordship sees the accompanying report, which is at page 12, it also reflects the same thing.
My lord, the petitioner municipality has the permissive possession of that land, and my lord, that was to the municipality, my lord.
What is it? Sorry.
Secondly, my lord, we have already issued, my lord, stop construction notice against them, and on that, for that, my lord, this representation has been filed to cover up this. Stall is constructed 20 years ago. On the 20 years, the stall is there. In year 1998, the land was handed over.
This record does not form part of this report.
The portion which is the petitioner claiming that talking when English and English, that portion is always itself illegal construction, my lord. Or that the construction of that portion, my lord, stop construction notice has already been issued. Counter blast to the
notice, keep notice.
In whose possession is this land, sir?
My lord, Roads and Building Department, as per
Your
rights.
road and building department.
Fine.
So you are free to take action if you want to. They are saying it's their land, or they are occupying their land. How are you occupying this land?
I have the papers, my lord, that that land was government land was handed over to the municipality for the permissive possession.
Where is that?
That is separately given, my lord. That is the letter, my lord.
But the land doesn't belong to government of West Bengal.
My lord. Are server.
Hand over to the municipality, my lord.
1448.
But the ROR they have annexed at page 19. It belongs to the state government.
I have also placed the
These
papers, my lord,
the
in the year
the stalls where they have been constructed, that belongs to the roads department because it's a part of the highway. The sketch map also makes it clear. The BLRO himself has measured the area and said so at page 13.
At page?
At page 13 of the report. Please see point 2 at the bottom of the
petitioner constructing in a land which is
kindly sees out of the such and such stretch, an area measuring 40 feet in length and 40 feet in width has been constructed upon by several vacant stalls. This pakka construction is situated in front of my building. And the demarcation in the picture is also there. That it's part of the road.
Just a minute.
As part of the, if your lordship sees the sketch map, towards the top there is the NH pillar written. The line runs straight. That is part of the highway, and the stall is directly on the highway.
So why you're not taking action?
Kindly direct so that I.
If the land belongs to you, you take action.
well, I have already handed over because, my lord, that land was handed over to the municipality for the permissive possession, my lord. That paper was I have already given.
What is permissive possession?
Permissive possession for construction of the stalls, my lord. For the public purpose, my lord. And my lord, moreover, my lord.
Sir, if this land belongs to,
Building of the petitioner is constructed in a land which is.
I'm not getting it. I'm not getting into the building of the petitioner. I'm only concerned about the NHAI encroachment. If there's an encroachment by NHAI, they will remove it. If that is their land, they will take action.
Because long ago, my lord, in the year 1998, that land was handed over, my lord. And after that, my lord, in 20 years ago, the stalls was constructed, my lord. In the year 1998, my lord.
Whenever the stalls are constructed, will not make a difference. Is it your land?
That is
NHAI is saying it's their land.
Go to the municipality, my lord. Kindly go through the papers, my lord. Kindly, my lord.
What paper?
Kindly, send me. I will.
You file your affidavit. It's better you file your affidavit.
That is the papers.
You file your affidavit. Learned counsel for the respondent Conti municipality. Just take down. A report in the form of an affidavit is filed by respondent number 6. The same is taken on record. Full stop. From the report, it is evident that from the report, it reads that the land belongs to the
Roads department.
roads department. Full stop. It is further stated in the report that the construction which has been carried out is on the NHAI and is within, it's considered on NHAI, full stop. Learned counsel for the respondent Conti municipality disputes the said contention and states that the land was duly transferred to the municipality. Full stop. He seeks and is granted. How much time you want?
8 weeks, my lord. And my lord, I want.
How much time?
I want to file an.
How much time?
8 weeks.
8 weeks. 2 weeks time to file.
My lord, kindly 3 work. On time is far away.
Don't try to act smart with the court, sir. Do you understand that?
And my lord, I want to file an exception to that report filed by the state.
You file your first report.
And kindly,
3 weeks time to file his report.
and kindly direct me to serve the copy of the report filed by the state.
Report within 3 weeks, exception to the same if any within 1 week thereafter. List after 4 weeks, after 5 weeks. Etc.
কিন্তু আপনার রেকর্ড কারেকশন যদি অন দ্য বেসিস অফ পারমিশন petition you take his name before the BLL অবশ্যই
Because of 14 also, I'm appearing on behalf of.
In this matter, my lord, by the order dated 8th October 2024, on the Honorable Court directed the municipality to appoint a surveyor to make an inspection to submit a report. A report was submitted.
Where's the report?
Sir, no report has been served to us, my lord.
Where's the report? You have got a copy?
Yes.
You want to file your exception?
No, the report is in my paper.
What is there?
No, kindly see this report first. When I am reading that report. As per your order, by memo number such and such dated, I have inspected the site of Supraditya Mondal and Sri Suparna Maiti at Mauja Atilaguri, ward number 9, in presence of both the parties and respective ward councillors with municipal enlisted surveyor. After verification, it is found that, kindly note that, and that the 450 is open space at the ground floor in between both building construction. But Suparna Maiti has extended slab over the ground floor, first floor, second floor, up to 450 There is no open space, fulfilled enclosed, covered by the Suparna Maiti over the ground floor in between both the building. It is in violation of the resolution of the chairman, Contractual municipality. And therefore, up to 450 and only there is a vacant space, 450 what she has their private respondent, entire up to third floor, entire cover casting has been done.
Not the report.
There is no open space. In between the two building, my lord, 1.6 inch was the vacant space. Entire place has been covered. I made this application before the municipality. This is unauthorized, let it be demolished.
Yes, take action.
Yes, my lord, may I say, my lord, something?
Yes.
My lord, kindly, my lord, sees what is the report. So, Suparna Maiti has extended slab over the ground floor, first floor and second floor up to 450 My lord, only 450 millimeters.
Yes.
Extended
That is unauthorized.
450 millimeters. My lord, that won't come within the centimeter scale also.
Hmm.
450 millimeters. And this is, my lord, my learned senior friend is alleging, my lord, my unauthorized construction, my lord. Two existing structures were there. They have bought an existing structure. I have also bought an existing structure. Thereafter, after purchasing, my lord, he is alleging, my lord, unauthorized construction on my part.
Now, why you will cover this 450 Municipality,
450
and
millimeters of
municipality adopted
unauthorized
resolution.
construction, my
This
lord.
space must be vacant. Municipality adopted resolution. The city didn't care for it.
You act in accordance with law, whatever you have to do. Yes.
My lord, their report only says, my lord, only 450 millimeters of unauthorized construction.
Whatever it is, even if it's 1 millimeter, that has to go.
But this won't come within the centimeter scale also, my lord. 450 millimeters. But how they could
How
have
much is 450?
450 millimeters?
The survey report, my lord.
That is the report
Survey
given, my
report
lord.
also.
450 millimeters of
one
unauthorized
How much
construction.
would be 450 millimeters, sir?
But I tell you also, 1.6 inch vacant place in between the two buildings.
Yes.
Now, what they have, she has done, entire vacant space has been covered.
My lord,
By roof plastic.
he's
He's
saying
not
that
saying
won't do, my
entire.
lord.
He's only saying 450
This is vacant space. That's why. That's why.
So how much is 450?
450, 1.6 inch. This is the survey report. Kindly see the municipality survey report. I have annexed the municipal survey report.
You file your affidavit also.
The parties, my lord, for
So
the
already, my lord, a partition suit is pending, my lord, before the trial court. And his
I
prayer
made the
was also, my lord,
representation, my
for
lord.
partition, my lord, before the municipal authorities on the first round.
both are fighting, my lord, for 6 inch place.
1.6 inch. 1.6 inch. But kindly see the survey report.
Survey report,
Municipal survey report.
এটা ও আবেদনকারীর মধ্যে উক্ত 6 ইঞ্চি সম্পত্তি লইয়া বিরোধের সৃষ্টি হয়। That's the
Page 70. Kindly see. Page 70. This is the
You
Bengal.
are here only to trouble people, nothing else. Your brothers, sisters.
No, no, no.
Also,
Then?
they are- both are traveling.
Neighbors.
Both are my lord, neighbors. Neighbor?
He doesn't have any unauthorized construction. His building, no unauthorized construction.
Both building are unauthorized, my lord. The both building does not have any side space, my lord. Only 1.6.
So demolishes also.
Between both the buildings.
Demolishes also.
We proceed direct. Both the building with that. Both the building.
You file an action taken report
Both the against both the buildings.
against both the buildings. That is much better. Take down. The report has been filed by
ফাঁকা জায়গাটা বন্ধ করে দিচ্ছে না, পুরো ফাঁকা জায়গাটা।
by respondent number 2 and 3. Full stop. The same is taken on record. Learned counsel for the respondent states that after a inspection, it is found that 450 mm open space found at ground floor in between both the buildings constructed by the petitioner and the private respondents has extended slab over ground floor, first floor and second floor up to 450 mm, and as such there is no open space in between both the buildings. Full stop. Learned counsel for the respondent submits that both the owners of the building have encroached upon in the open space. Full stop. He seeks and is granted. How much time? 4 weeks? 4 weeks time to file an action taken report.
And take a report, not my lord. We will call both the parties and hearing and order passed, then we will proceed under section 200.
I'll give you 8 weeks. You do whatever you have to do. All right. Action taken report within a period of 8 weeks.
And dispose of the matter, we will give a hearing both the parties, and after that, my lord, we will proceed both the in respect of both the construction 280.
No, you file a report, demolish both and come back. I want to see the picture. How do you demolish both the buildings?
Yes, my lord. We'll communicate the order.
Yes.
What I am making submission that the open space has been filled up. Open space. The open space, my lord, which was vacant.
They will do whatever they have to do. They will
No,
demolish both the
whatever they will
buildings.
do.
Your building, his building.
I'm not making that submission.
Yes.
I am making the submission that the vacant space 1.6 inch. Municipality adopted a resolution. Don't fill up the same. Don't fill up the same. Both the parts
Sir.
are by the municipality. And don't open, let it be open, not filled up it. But in spite of that, the private respondent has custody by filling up this.
The parties are amicably settled that they will keep the land vacant.
They are both constructed. None of them have left the mandatory open space. Right? Take action. Within a period of 8 weeks. Report within a period of 8 weeks. List on. Give after 10 weeks. Give after 12 weeks. 11.
Building huh?
11
Grateful.
My lord, I am for the petitioner, my lord.
Yes.
Time for the state.
My lord, I am praying for 2 weeks time to file the exception, my lord. My senior is suffering. No, 15.
You already took 2 weeks time.
Yes, my lord. My senior is suffering from very high fever, my lord. So I will have to make the exception, my lord. Kindly grant me only 2 weeks time, my lord.
All right. Learned counsel for the petitioner seeks and is granted further time of 2 weeks to file his exception to the report. List on. List after 4 weeks.
That I beg to appear on behalf of the petitioner. There was a direction upon the municipality, my lord. Pursuant to that, they have filed an affidavit also. My lord, my claim has been substantiated. They have found that there has been illegal construction. So, my lord, I brought before your lordship in the writ petition that they initially found there was an illegal construction. They asked the, my lord, private respondent to remove that. That, my lord, they didn't remove. They have yet again, my lord, issued another notice. Pursuant to that, my lord, I was before your lordship.
Well, a report has been submitted as per your lordship's court directions, my lord. At page 9, my lord, direction to submit all the deeds within 3 days. And thereafter, official will inspect the premises on specific date. The notice was received.
Yes, what is left?
My lord, they have found it. They will proceed in accordance with law.
Yes.
Because the steps will follow. So far as my grievances before your lordship, my lord, that has been substantiated. That is my respectful submission in terms of this affidavit which has been brought before your lordship.
And board of resolution has been passed in presence of both the parties, and both the parties appear and sign the attendant registered. And all the order has been passed in presence of her. My lord, notice was issued 218 for the demolition, my lord, 2 phase. One is the remove of the unauthorized construction, including the iron staircase, roof tile, etc. And there is 2 types. One is the roof tile before the roof has been blocked for obstructing the egress and ingress of the common passage.
Yes.
That has been mentioned, my lord, at page 13.
But so far as this part is concerned, lordship will kindly indulge me to point out at page 6 of the report, paragraph C, 8, page 6 of the report submitted by my learned senior friend. At page 6, paragraph C, it says, my lord, I should have pointed out. Additionally, it was observed the assessment for the record floor has yet not been completed. That, my lord, takes it to another step because it's probably in connection with the plan.
No, its connection is property tax.
Yes. Well,
No
that,
plan.
yes.
All right, so there's nothing much.
So the illegal structures needs to go in accordance
I'm
with
for the
law.
respondent number 5, my lord.
Yes.
We have filed an appeal against the order passed by the military municipality court. This is the
What has happened? What is the order in the appeal?
no order has been filed. We have filed it.
Very
Well, a caveat has been lodged before the
We have
concerned
filed a
civil.
caveat.
Yes,
Prior
and
to
no,
first-
no copy has been served upon the municipal
That
authority
is
against
a
that order.
different, but that it goes in a
Uh,
different.
take down. In pursuant to the order dated 4/7/2025 passed by this court, the municipality had conducted an inspection on 15/7/2025 in presence of all the interested parties. Full stop. The parties were directed to appear for a hearing on 23/7/2025 at 4:30 p.m. before the Board of Councillors of the municipality. Full stop. After the hearing, a reasoned order has been passed by the municipality on 24/7/2025. Full stop. It is recorded that during the inspection, the following illegality has been observed. ये टिक टू टिक कर देना. Page 12. Learned counsel for the respondent states that during the hearing, he had voluntarily.
That submission is not right. As per my client is also here. They have stated not. They have said not voluntarily. They have written it forcefully.
So and so क्या लिखवा है उसको हटा देना. क्या है following illegality has been observed. Full stop. In view of the said illegalities, the municipality had passed the order whereby the respondent has been directed to remove the entire unauthorized construction, including the iron staircase and roof grill work, within 7 days from the receipt of the above order. Full stop. Failure to comply with the said order shall result in summary removal of the said unauthorized construction by the municipality without any further notice, and all costs incurred shall be recovered from the respondent. Full stop. In view of the said report, learned counsel for the petitioner submits that in view of the said report, nothing survives in the present petition. The respondent corporation is directed to comply with the order dated 24/7/2025 in accordance with law as expeditiously as possible. Since the grievance of the petitioner has been met, as expeditious as possible. In the above terms, the present petition is disposed of. Nothing else is.
Yes, because my lord will kindly not record that my grievance has been redressed because
in view of the said, nothing.
yes, it may be
The
disposed.
present petition is disposed.
Because suppose municipality doesn't, well, I have.
It petition disposed of.
Yes.
Yes.
My submission, the appeal has been filed against that order.
I'll record it. What is there is no
Give me the number, my lord.
18.
learned counsel for the private respondent states and appeal number miss appeal number so number. What is the number?
Municipal 18/2025.
Copy data.
My lord, if it is a misappeal, it may not be, my lord, against
Municipality.
this mean.
Municipality
It's appeal number
well, as per the rules,
298.
No, no,
298.
নাম্বারটা
देखो ये क्या कहा
না না তা বলছি না
कहाँ है
এইটার এগেইনস্ট
disappeal
কিনা
कुछ
সেটা
लिखा
জানবো
हुआ?
কি করে কস্টেডটা
against the order passed by the Board of Councillors, my lord. I don't know.
that needs to be
18,
recorded. ওটা তো ওই ওর অর্ডারে সেটা দেখে করিয়ে নাও তোমারই
Yes,
Yes, my
has been filed,
yes if your lordship is, my lord,
but there is
But there is
No
no stay
stay order.
We will carry
there's
out.
no stay order
না না
passed
stay order নেই
by the there's no stay order in his favor.
Therefore, municipality carry out order.
Thus the municipality is directed to carry out its order in accordance with law.
grateful, my lord.
Get for it, but within certain time, my lord. There is no time.
Expeditiously, I have used the
As early as possible. As early as possible. Get for it.
May I please, madam?
Short question.
But this is an application, my lord, against non-action on the part of the Kolkata Municipal Corporation, my lord, regarding change of user under section 416. My lord, a residential building has come up, my lord. The building plan was sanctioned as a residential one. But there, my lord, in respect of 2 flats, my lord, commercial activities are being conducted. My lord, objection was raised. As a result, my lord, some hazards are coming. The representations were made to the corporation authority. My lord, no apparent action has been taken to the best of the knowledge of the writ petitioner. But that's why this writ petition has been made.
What is it? I'm not able to understand. What has happened?
Yes, my lord.
Show me the details, sir.
Yes, yes.
What has happened?
Your lordship will kindly see in paragraph 3, I have stated the petitioner, my lord, is a flat owner in respect of the said building. So unfortunately, I'm just reading, my lord, in paragraph 3 from 4 lines, but unfortunately, it was found later that this.
Where are you reading? Where are you? Which page?
Yes, my lord.
Which page?
At page 5 of the writ petition, my lord. Paragraph 3. That the respondent number 11 has let out one of the said 2 flats to respondent number 12, who is carrying on commercial activities in the said building from the said flat being let out. That many good number of outsiders regularly paying visit every day in the said office of the respondent number 12 and causing disturbance to the other residential inmates, which led to lodge written complaint dated such and such before the respondent number 9, and redressal of the grievance of such mischief was sought. Though the same happens to fall in deaf ears, since no steps were taken to redress the said grievances. But that is annexure P1, my lord, as the representation. By another written complaint on March 20, 2023, attention of the respondent number 6 was drawn, wherein same and similar allegations like earlier one was raised again, and redressal of the grievance was again sought for. But that is annexure P2. You will also then kindly come to then a notice was given, and my lord, a hearing was fixed at paragraph 7, my lord will find. Hearing was fixed and order was passed, signed by, my lord, the respondent authority, annexure P4. Your lordship will kindly see. This is the order at page 21 of the writ petition.
So this is in your favor.
Yes,
Order is passed in your
order
favor.
was passed in my favor, but thereafter no steps have been taken.
Yes.
This is an order of November 2023. Further, after receiving a complaint that this has not been complied with, we conducted another inspection. From our record, we found that after this order, the person responsible he has obtained a license, certificate of enlistment for running of consultancy service. That is permissible. But so far the change of use is concerned, that they have not done yet or prayed for. So we are under compulsion to take step. And so far the infringement are concerned, that is also in our consideration. We have proceeded. We will take step accordingly.
File an affidavit.
Only
State what you have done.
only one thing your lords will appreciate, that certificate of enlistment does not entitle any person to carry on any business, my lord.
No, but depends what kind of business he is carrying on.
No,
It is
in
only
any event of the matter, change of user, my lord, it's a settled law, my lord. It has been settled by this honorable court.
Consultancy
My lord,
service
may peruse this judgment.
Let
There
them
is
file.
Yes, my lord.
You are giving Mr. Which judgment are you giving?
But I am referring, my lord, 2002, volume 2, Calcutta High Court Notes, page 662. My lord,
Justice Barin Ghosh judgment.
yes, my lord. Yes, my lord.
File your report.
The report is with me,
Report by way of an affidavit, not just one pager report. Take down. The petitioner in the presented petition is aggrieved by the inaction of the respondent municipality in not taking any steps for implementation of the order dated 8/11/2023 passed by the special officer, building, passed by the special officer building, whereby the private respondent number 11 and 12 were directed not to run the office in the name and style of Vijay Management Solution from the residential building premises 136 Charu Chandra Place East, Ward number 089. Residential building वो ब्रैकेट में कर देना कादम्बरी ठीक है residential building complex named as Kadambari.
Yes, madam. The building is titled as Kadambari.
Situated at कर देना 136 Charu Chandra Place, Tollygunge, Calcutta. PO Tollygunge, Calcutta. Full stop. Learned counsel for the petitioner submits that despite the said order dated 8/11/2023, no action has been taken against the private respondents. Full stop. Learned counsel for the respondent municipality submits that seeks and is granted. How much time? 2 weeks, so you'll do nothing. 3 weeks. 4 weeks time to file his report by way of an affidavit, a reply to the same, exception to the same, if any, within 1 week thereafter, list after 6 weeks. 15 September.
15th September. Deeply obliged, my lord.
Lordship, I am for
For the
agency
petitioner.
led by Mr. Shantiban Banerjee. I praying for short passover. Then not today.
What is the matter?
My lord, by on last occasion, my lord, it was directed to file my lord report by way of affidavit upon the respondent, my lord.
Do you have any instruction?
No, Lordship, I have no instruction.
Not today.
Grateful, Lordship.
Rest of the matters tomorrow.